writ petitions on Monday. These are two schools whose affiliations have been cancelled by SEBA without any show cause notice or hearing.
Monday.
Yes, Lordship.
Okay.
May it please your lordship. My lord, I beg to mention item number 29, 30, 31, and 32, lordship. I want to file my rejoinder, lordship. I need some time more time, lordship.
29.
30, 31, 32, lordship.
Oh, 29 to 32.
Lordship. I need 4 weeks time, maybe, lordship. Because I have to file rejoinder.
Okay, on request made by Mr. K. Magindal and accounting for the petitioner. 4 weeks time is allowed to file rejoinder to the counter filed by the respondents.
My lord, this is an IA, my lord, correction of typographical mistake. This may be listed on Monday, my lord.
We'll have it on Tuesday.
May I please, your lordship? May I pray for listing of an admission matter, 2021 matter, your lordship,
Yeah,
on 16th or 17th, your lordship?
yes,
Lordship,
16.
lords, problem.
May it please your lordship. Lordship, I beg to mention one matter for listing on Wednesday, lordship. The matter was listed last on yesterday, lordship. Part heard matter, your lordship already heard my part. Only the respondent has to show the citations, lordship. So on Wednesday, lordship.
Obliged.
Please, your lordship. Lordship, I beg to mention item number 50, your lordship.
50?
50. I appeal for respondent number 5, your lordship. In this matter.
Total matter.
Lordship, it's a selection matter, your lord.
IA.
I had filed the I.
Oh,
College has filed an IA seeking leave to fill up the post, your lordship.
oh.
I seek any date next week, your lordship. Today, Mr. Patwari is not available, your lordship.
Okay, heard Mr. M.P. Sharma, then counsel for the applicant. On request made on behalf of
Mr. J. Patwari, your lord.
J. Batwari, Learned Counsel for the
Respondent number 5.
respondent number 5. List the matter again on, when do you want?
Any date next week, your lord.
16.
Lord.
May I please, your Lordship? Lordship, I beg to mention item number 42.
Hmm.
Lordship, the matter may be adjourned for the day.
Why?
Lordship, my senior Mrs. A. Bujarbora, due to some personal difficulty, she couldn't come.
Okay, on request made on behalf of MSA Bajabara, Learned Counsel for petitioner, list of the one.
May I please, your lordship? Lordship, I beg to mention item number 14, lordship.
Item?
Item number 14, 1-4. We have filed affidavit in opposition.
Oh.
Lordship. So that may be common record.
Okay.
May it please your lordship, I beg to mention for listing of for Monday, IA is for implementation for private respondent in item number 10, which has been listed on Monday before this honorable court.
May I please, your lord. Lordship, I beg to mention item number 8. Lordship, this matter wrongly fixed with item number 7, lordship.
Oh.
So, lordship, item number 8 kindly adjourn for that.
Okay, you wait for some time, let it reach.
Lordship.
May I please, your lordship? I beg to mention the matter, writ petition civil 599/2024 may be listed on 14, your lordship. 14/5.
16.
16. Must oblige, your lordship.
Lordship, I beg to mention item number 45, Lordship. Lordship, the matter may adjourn for the day, Lordship. Lordship, my senior is not well, Lordship.
Who's your senior?
Lordship, I am appearing on behalf of SK and Muhammad, Lordship.
Okay, on request made on behalf of Mr. S.K. and Muhammad, Learned Counsel for petition, list of the one.
May it please, your lordship?
Oh,
May it please, your lordship? Lordship, I beg to mention item number 37.
yes.
Assisting counsel, Mr. M. Monto is out of station.
What
We
do you
had put forward our adjournment request yesterday itself,
want? Oh,
and we had taken consent from the other side as well.
when do you want?
After 2 weeks, lordship.
M. Mahanda,
M. Monto.
on request made on behalf of M. Mahanda.
Lordship, there was an interim order passed
Learned
earlier.
Counsel for the petitioner. List after
2 weeks.
2 weeks.
Interim order, there was a, it was
For the
passed.
possibility to continue to the next.
Much obliged.
May I please, your lordship? Lordship, I beg to mention item number 24, my lord.
Conducting counsel is out of station. He is on leave, my lord. M.H. Chaudhary.
Oh. When do you want?
After 2 weeks, maybe.
On request made on behalf of M.H. Chaudhary, let me counsel for petition, at least after 2 weeks, yes.
Oblige.
May I plead Lordship, I beg to mention for listing of WPC for orders. Last it was listed on 16th February.
Oh.
Can it be listed again on last week of this month?
Okay.
Any date, Lordship.
30.
Oblige, Lordship.
May I pray, my lord, for my lord, non-payment of arrears salary, my lord. May I pray for listing in the next week, my lord, any convenience day, my lord,
Next week is quite full, we'll have it on 27th.
27th. my lord. Can it be earlier, my lord?
27th.
27th. Oblige.
Item 1 of daily list, motion. Particular occasion. May I please?
My lord, we have received the report of the inquiry committee.
1 minute.
Say,
This is a personal appearance.
my lord, only in case, my lord, the inquiry report was not received by us on the then at 2 o'clock, the personal appearance should be. Mr. Srina, my lord, we have
1 minute.
last order. Hey, last order of the company. Last report to the last order today, last order.
No. There's no condition. He has to appear.
Order sheet has
1/5/2024.
no order to be. So will give me a.
Order to give me this.
This, my lord, the last paragraph. If I see, তুমি কবা না মই কম? List this matter on 10/5/2024 on which date Ms. Fukan shall place before this court the additional facts which have been now emerged in the matter in terms of examination made by the 3-member committee in the said event. The said facts as stated now now to have been emerged is not placed on record on the next date fixed. The Secretary of the Government of Assam shall remain personally present before this court of law. In case it is not placed.
Okay.
And so the inquiry report we have received.
Oh.
And some have been also transmitted by email, my lord, we have given a copy. Today, my lord, I was just praying for some time to bring on record the entire inquiry report, all the findings, so the matter can be, my lord, adjudicated properly.
My humble submission is that, my lord, today is the 8th day. This case is listed for 8 times, my lord. And I'm praying for, my lord, they have taken time to file affidavit on several locations, but they have failed, my lord.
Have you got a copy of the inquiry?
No, that is not served upon me.
That is why, my lord, I was praying that we bring it on by way of an affidavit. Lordship will have page 4 of page 5 of the report, my lord.
Yes.
The last paragraph, my lordship will see the difficulties which we have found out in preparation of the list. That is one part. And then lordship would find at page 5 of page 5, the last paragraph, my lord. At no level, the third line from the bottom of the second last paragraph I'm reading, my lord. Or the line before that also, which the present claims of the appointments are going on. Yet the list was prepared or based on list signed only by the DO Kacha, which clearly smacks of manipulations and malafide intentions. At no level any attempt was ever made to do away with these issues or deal with the issues in a more pragmatic manner as directed by the Honorable High Court. Thus, in view of the findings, the additional facts that have emerged from the inquiry, the government seems to be right in when it expresses inability to approve the list of the candidates. There are difficulties which would require the consideration of this Honorable Court, my lord. Simple.
The stand which they have brought now, my lord, they ought to have brought in the first round, this is the 5th round of litigation. They are barred by the constructive res judicata, my lord. The new ground they have developed now.
It is not a new ground. This ground was
Yes,
there.
this honorable court, my lord, has directed them to cause an inquiry. Page 73 is the inquiry report. And thereafter, they have called the interview, my lord, that they have conducted the inquiry and they have called all the teachers and the candidates to appear, and they have submitted their documents, everything. Page 73, as per the inquiry report, my lord, of the director, as per the direction of this honorable court, has been done. Now at the final stage, after the 20 years,
You filed the inquiry report.
Let
him see.
Yes.
Let him, but I'll give you a short time.
Good, yes. Good. Should we give me a week time? At
one,
the maximum a week's time.
my lord,
We'll draft the affidavit, we'll have it signed and verified by Tuesday or Wednesday, and we can have it filed by Friday.
Okay, we'll take up on Friday.
It will be after a week.
Not Mr. P. Purkayastal, Learned Council. for Education. Mr. R. Majumdar, Learned Standing Council,
Department of School Education.
Department of School Education, has produced the inquiry report. Dated 7/5/2024.
Madam.
And press for weeks time to enable him to place on the court by way of affidavit. Press allowed. Release from. We'll have it on Friday, 17th. 7th.
Lordship, I will to file the affidavit in opposition also, madam, along with the report.
You want to file affidavit? in
We have to file a affidavit in opposition because you have to contact the petition, madam, only the report would not do. The
So you want to not only place the inquiry.
also file the affidavit in opposition in the entire.
Okay, then you say that. Has produced the inquiry report. Dated 7/5. Stop. He prays to file, he prays for weeks time to file affidavit in opposition. And also to place the inquiry report on the court.
my lord, one small observation we made, my lord. No process of selection should be made in respect of this till the disposal of this.
That is what we.
There is a prayer in
This the matter
apprehension.
on September. We'll have it on September.
My lord, if they initiate any process during the
Obliged.
pendency of the writ petition, my lord, then
We
the
will come back with a petition or an I.
that is.
Obligement.
Two.
May I please, your lordship, kindly pass over for time being, lordship.
What time being?
Thank you.
Here, my lord, we have received the instruction, my lord. Communication, my lord. My lord, petitioner may file an appeal before the appropriate authority, my lord. Under section 14 of the Act, my lord, petitioner, that is, instruction is there, they have filed a representation, but without any document, my lord, supporting their, my lord, claim, my lord.
Okay, let.
My lord, any other day?
Next week? Next week, lordship.
Okay. On the, who's your senior?
SB Laskar, lordship.
On request made on behalf of SB Laskar, let us come. Release the matter after 1 week.
Lordship.
Obligement.
Three.
My lord, in this case, I have received instruction, my lord. As per the order of this honorable court, my lord, new SMC has already been constituted, my lord, and it has been approved by the BEO, my lord.
My lord, your lordship may kindly peruse the order dated 9/2/2024, my lord. The matter
9/2/2024, my lord.
matter pertains to selection of president of the school managing committee of the Dhumpura Girls Semi School, my lord. So by order dated 9/2/2024, my lord, this honorable court directs the concerned district elementary education officer to take steps in terms complying the provisions of Rule 13 of the Assam Right of Children to Free and Compulsory Education Rules 2011, my lord. So My lord, this is the order in terms of the order dated 9/2/2024. On the same day, this letter has been issued, my lord. And the date for conduct of election has been fixed on 13/2/2024. Fourth line, my lord, of a first paragraph, my lord. Although it seems that originally it was a different date, my lord, subsequently by handwriting, my lord, it has been made 13.
So now what the instruction says is,
My
the
lord,
SMC has been constituted and the president has also been selected.
yes, my lord. In assuming that in terms of this letter, 9/2/2024, my lord, on 13/2/2024, if it has been, the president has been selected, my lord, that is in violation of the concerned rule, my lord.
No,
Because-
no. This was done when was this done?
My lord, 13/2/2024, my lord.
Yes, my lord.
Second paragraph, my lord, and accordingly, a fresh school managing committee was constituted on 13/2/2024 as per the guideline and also selected as a person, namely so-and-so, my lord, among the parents.
Yes.
After the order of the.
My lord,
So what is your prayer here in the writ
My,
petition?
my lord, the order dated 9/2/2024 says that it has to be done strictly in compliance of the rules, my lord. If your lordship takes up the rules, my lord, rule provides that there must be 7 days notice, my lord. So where is the 7 days notice if it has been held on 13/2, my lord? Or the order was passed on 9/2/2024. If your lordship peruses the order dated 9/2/2024, last paragraph, my lord.
Yes, 9/2/2024.
Yes, my lord. This letter has been the letter issued by the district elementary education officer notifying that election will be held on 13/2/2024, my lord. My lord, but this honorable court directed that the election has to be held in terms of the complying with the relevant rule, my lord. The rule says that, my lord, at least 7 days notice should be given, my lord. Where is the 7 days notice in terms of the order dated 9/2/2024? If the meeting has held on 13/2, my lord, then where is the 7 days notice, my
Where
lord?
is this rule 13?
13/3, my lord. May I read the rule?
Which book you are referring?
Yes, my lord, this one. Page number 256. Yes, my lord, page 256. Rule 13/3, my lord. Page 256, my lord. Rule 13/3(1). The headmaster, head teacher of the concerned school shall convene a general meeting of parents, the adult members of the village, tea garden area, ward, NC area concerned, ward members, councillor, Gaunbura, village headman, local health worker, Anganwadi workers within 15 days from the date of receiving the intimation from the competent authority to constitute the SMC. She has to give 7 days advance intimation to the concerned invitee regarding the date, time, objectives, and venue of the meeting, and also fix it on one notice board of the school and at least 4 or 5 prominent places in the villages were concerned. So the rule mandates that there must be 7 days notice, and this honorable court has also directed for complying with these rules, my lord. Now, my lord, by issuing the order dated 9/2/2024, they have convened the meeting on 13/2/2024 and because the petitioner is not aware of the meeting, my lord. They have they have done, my lord, to select their.
Okay, then let them file the affidavit.
Yes, my lord. It's a short date, my lord, because my lord, from 9/2/2024, on 3 occasions they could not produce the instruction also, my lord.
Part Mr. D.P. Bora. Learned counsel for the petition. Mr. S.M.P. Chishti.
For 1, 2, and
Learned
3.
standing counsel for the secondary education.
E-
Department.
Elementary, Lord.
For the elementary.
Yes, this is an elementary case. Lord.
Elementary education department. SMT Chishti, learned standing counsel for elementary education. Is allowed. How much time you require?
2 weeks time.
Make it sure you file it in 2 weeks.
Yes, yes, I'll.
It's allowed 2 weeks time to file affidavit in opposition. Stop. List the matter again of 28.
My lord, in the meantime, may I pray that, my lord, because your lordship has seen, it is in clear violation of the rules. And order dated 9/2/2024 has, my lord, says that, my lord, in the meantime, the BEO, my lord.
No, that order is there.
Yes, my lord. The BEO should act as the president of the SMC. So in the meantime, BEO should act as the president, my lord. But the elected president who has been elected in clear violation of the rules, the BEO shall function, my lord.
Let
Yes,
the
let the
affidavit
affidavit
file.
come, lordship,
My
let the
lord,
affidavit come.
Order dated 9 to
We'll dispose it of on 28.
Yes, yes, Lord.
My lord, in the meantime, because order dated 9/2/2024 specifically stated that.
If there's violation of rule 13(1).
My lord, apparently your.
1 minute.
Yes, my
Bora.
lord. Yes, my lord.
If this violation of 13(1), automatically this selection will go.
Yes, my lord.
Then
Yes.
Yes, my lord.
we'll fix it on 28. Yes, them come with the affidavit, then we'll dispose of.
Yes, your lord.
Yes,
If it is in violation of rule 13(1),
yes, my lord.
automatically the SMC in the.
That's why, my lord,
election
is-
of the president will have to go.
Yes.
Because in terms of the documents produced before lordship,
Oh.
my lord, it is
No,
apparently
that I
clear that.
noticed.
Yes,
That
my
I
lord. So
noticed.
may I pray that in the meantime, the BEO, my lord, because by the order dated 9
No, no, sir, 28 lordship
2024.
fix it for final disposal. Let it come.
We'll have it on 28.
My lord, that observation may be passed, that endeavor shall be made to this.
Yes, in endeavor shall be made to dispose of this on the next one.
Oblige, my lord.
Five, six lordships.
4, 5, 6, and 7.
No, here only instructions were called for. See, here lordship, the authority has constituted inquiry committee, so lordship may let the matter come after 1 month, lordship, 4 weeks. Then all pictures will be clear, lordship. Hereby violating the provisions of lordship 2017 Act, lordship, they have given the benefit to the petitioners, lordship. Lord. When petitioner approves before his honorable court for taking the retrospective benefit, then lordship, the whole picture come out before the authority, lordship. By violating all the norms, lordship, some officials have, lordship, done that part, lordship. So, lordship, now authority has constituted committee, lordship, high-powered committee, lordship, to inquire the matter, lordship, the persons who were involved in these issues, lordship.
Okay.
So,
Let
lordship,
them have the third Adhikari and counsel for the petition. Mr. K. Gogol, learned standing counsel, higher education,
lordship.
has produced an order dated 6/5/2024, by which a director level committee has been constituted for verifying scrutinizing the matter regarding upgradation from assistant professor within bracket tutor to assistant professor by violating clause 4 within bracket 2
Lordship.
of the Assam Education within bracket provincialization of services of teaching and reorganization of educational institutions Act 2017. As amended. Stop. He therefore submits Well, how much time?
Lordship, 4 weeks time, Lordship. In the meantime, we'll prepare, Lordship. We'll place the status report, Lordship.
To enable the constituted director to level council to submit this
Report, Lordship.
query along list of the 4 weeks.
My Lord may indicate that they will submit the report, Lordship. My Lord may in the order indicate that they will submit the report on the next reasonable date.
You want to submit a report?
Lordship may indicate in the order, Lordship. That's the
After 4 weeks, on which date? Then the standing council higher education shall submit a report. Okay.
Apply the rules.
5, 6, 7 are same. 5, 6, 7.
Same order?
Same order.
Same order.
My Lord may keep it as a part of the record, this.
Oh, the order dated. 6, 5, 24. Then you have to submit 3 more copies in all the editions.
Lordship. 8. Apply the rules.
May I please, Your Lordship? In this case, Your Lordship, I have filed an additional affidavit today itself, Lordship. So, Lordship, may I adjourn for that? This
It's a bench 5 matter.
It is a bench 5 matter.
Yes, Lordship.
Then let it come before the appropriate.
Lordship.
It is submitted by the learning council for the parties. That this matter pertains to bench 5. Registry is important that release the matter before the appropriate.
Deeply.
9.
May it please your Lordship.
Yes.
My lord, the petitioner here is a complainant and she is working as an assistant professor in the Department of Pediatrics at AIIMS Guwahati. She is a victim of sexual harassment. And the report of the ICC, as per the POSH Act, has held respondent number 6 has done act of sexual harassment, and as such, disciplinary proceedings and the misconduct should be initiated against her. My lord, the order of the ICC, the recommendation is at page 117, my lord. 118 it starts from, my lord. 118 inquiry report, my lord.
Yes.
This is as per the act of the POSH Act. And my lord, now I would like to take to page 122. Page 122, the conclusion part, man.
Yes.
The IC concludes that the aggrieved women, Dr. Nisha Toteja, the petitioner herein, was subject to sexual harassment at workplace due to hostile work environment caused by the respondent, that is Dr. Jayashankar Kaushik, acts of omission, commission, and unwelcome behavior based on witness statement and documentary evidence, which led to hostile work environment amounting to sexual harassment as per the Sexual Harassment Act 2013, so and so, and Central Civil Service Rules 1964, 3C2B. Accordingly, my lord, there was a recommendation. The recommendation is at next page, page 123. The IC recommends that the employer, the executive director, AIIMS Guwahati, shall take action of allegation of proven sexual harassment as a misconduct as per clause 13(3)(1) of the Sexual Harassment of Women at Workplace and 9 of the rules of the SH Act and as per the provision of Part 5, Rule 11 of the Civil Service Rule 1965. Now, as per the Act, my lord, the disciplinary authority, the appointing authority, should have taken a disciplinary action against for the misconduct. Now, what has the AIIMS done to protect the blue eye candidate? They have the respondent number 5, the employer, has acted himself as a disciplinary authority and has passed an order at page number 135, which he cannot do. And there is a judgment of this Honorable High Court itself. 135, my lord. My lord may see to Dr. Jayashankar Kaushik, that is the respondent number 6, to Dr. Nisha Toteja, that is the petitioner herein. My lord, the 6, the test of fairness being a psychoanalysis for any committee, the ICC report does not survive the test of fairness and equal consideration to both sides, leading to reasonable doubt. Hence, it would be a travesty of equity, justice, and fair play to accept this report with erroneous assumption and errors. Therefore, the report has not been accepted by the competent authority. My lord, he is not even the competent authority. I can show it to you, my lord, the aims regulation I have annexed with the writ petition. My lord, I would like to take you to the aims regulation, my lord. That is at page 81 of my writ petition.
Yes.
My lord may see the appointing disciplinary appellate authority for the various posts in the institute. My lord may see group A post. I am a group A post, my lord, that can be ascertained by page 83, that I am a group A post, that is the other post. My lord may see disciplinary authority is the governing body or the president. It is not the executive director here. And my lord, thereafter, there is a specific clause so that this executive director cannot act on his own. There is a specific clause at page 82 at column 1.
Yes.
At bottom, authorization of the director, All Indian Institute of Medical Science, to issue the charge sheet and the statement of allegation, penalties and suspension order after obtaining the approval of the governing body, the president, All India Institute of Medical Science, as the case may be. The notice, the charge sheet and the statement of allegation shall be signed by the director and on behalf of the governing body of the president, as the case may be, and the documents shall expressly state this fact, phrase like by order of the governing body or the president or the approval of the governing body or the president can be used on such document. My lord, my document has never been placed before the disciplinary authority. The first violation they have done is under the POSH Act, under the Central Civil Service rules, that once there was an inquiry, they should have placed it before the disciplinary authority to take initiate action. My lord, on that regard, I have to play a judgment of this Honorable High Court, my lord.
Yes, so who appears for the
Lordship, I'm appearing on behalf of Mr. H. Gupta.
Oh.
Lordship, he's on legs in court number 12. So the matter may be taken after some time.
after some time?
My lord.
Then.
Let me see, Lordship. My lord, the petitioner, while serving as a lower division assistant, was placed under suspension following his arrest in connection with the police case. My lord. And thereafter, he was placed, show cause notice was issued, my lord, which my lord will find at page 21.
Yes.
Page 21, annexure C is the show cause notice. And the show cause notice, my lord, it is very significant to note that, my lord, the show cause notice was issued under Rule 9 of the Assam Services Discipline and Appeal Rules, which holds the field. My lord, he submitted his written statement of defense denying the allegations. And my lord, annexure E is the order by which he was directed to appear before the inspector of schools in connection with the inquiry. And my lord, he accordingly appeared on that day. My lord, he was just asked to, his statement was recorded, my lord, and then he was asked to leave. There was no inquiry in the eye of the law. There was no presenting officer. There was no inquiry officer. So he was asked to leave after his statement was recorded by the inspector of schools.
Yes. Then what happened?
Then, my lord, I am aggrieved, my lord, by the annexure G inquiry report. Because there was no inquiry in the eye of law. There was no presenting officer. There was no inquiry officer to conduct the case. The allegations that was leveled against the petitioner, they were not proved by any witnesses.
So you are challenging the inquiry report?
I'm challenging the inquiry report, my lord. And before,
does this
my lord,
belongs to bench too?
I think this is not belong to bench two.
I think, my lord, this is only विषय,
Yeah.
it will be the tenth विषय,
अच्छा.
both the benches.
I don't think this is not best.
Bench
two. It purely educational here. It actually submission and verification.
state government applied, no?
Corporate. State government bench three, bench four,
Bench two, yeah.
bench to education, purely education.
So inspector of schools assembly, disciplinary. State government. Disposal, Java.
I don't know.
Representation as a disposal provided.
After the inquiry report, what happened?
After the submission of the inquiry report, my lord, I submitted a detailed representation, my lord, pointing out the legal flaws. That, my lord, will find at page 32, annexure H.
Yes.
That, my lord, details the numerous violations of Rule 9. My lord, I may submit, my lord, that Rule 9 of the Assam Services and Discipline Appeal Rules, my lord, they are mandatory in nature and it needs to be followed to the teeth. My lord will see from the representation that I have given against the findings of the inquiry report. In fact, there are no findings. The inquiry report, my lord, and I'll just draw your lordship's attention to page 30, my lord, page 30. Just an excerpt of the inquiry report to show how my lord, the inquiry report was conducted. There was no, the presenting officer was, although on paper, it is shown that the presenting officer was appointed. And there was no inquiry officer. I mean, there was no presenting officer. And my lord, the inquiry report was found, paragraph 4, my lord. Paragraph 4, heard the headmaster and heard Anwar Hussain, LDA. My lord will see the last but one paragraph. Heard the headmaster. He's an inquiry officer, my lord. Heard the headmaster so and so, and brief narration of the facts. And then, my lord, heard Muhammad Anwar Hussain, LDA. He is the delinquent official here, my lord. So the inquiry officer is basing his inquiry report on the oral submission rather than on the basis of the show cause notice. He is required to follow what is given in the show cause
Was the
notice.
presenting officer appointed?
There was on paper.
That I have to take instruction, which is for motion needed for the first day. I have to take instruction. And so far, the Lordship may kindly turn to page 31. Conclusion. Lordship, last 5 lines, Lordships. It was found in the inquiry that the petitioner accepted rupees 5,000 only from complainant Atiullah on 6/4/23. And at that moment, a team of vigilance and anti-corruption apprehended the petitioner lawsuit. He was caught red-handed while accepting the bribe.
But that is a criminal case, my lord. This is a departmental proceeding. Let us not confuse both, my lord. He was arrested, my lord.
Finding of the inquiry.
Okay.
Notice should go at this stage. I have to go examine anyway.
And my lord, I submitted a detailed representation. Representation meaning, my lord, after the conclusion of the inquiry report, I submitted a representation pointing out the various flaws and seeking the dropping of the departmental proceedings on the ground that it was no inquiry in the eye of law. No inquiry as envisaged under Rule 9.
So what do you want?
So, my lord, your lordship may dispose of the writ petition by directing the authorities to consider the representation that I have submitted on the inquiry report, on the findings of the inquiry
Will
report.
it help you?
My lord, otherwise, my lord, they may, otherwise, my lord, till such time he seeks his instructions, my lord, let there be a stay of the order.
Order lawsuit at this stage should not be issued, lordship.
Yes, my lord, the inquiry is
And this-
concluded, my
this
lord.
Representation, there's no issue, there's no issue, lordship, it's blank every.
My lord, they include,
The representation.
my lord will take into consideration the fact that the inquiry is already completed and an inquiry report has already been submitted. So there will be no prejudice caused to the authorities if my lord, the further proceedings are stayed. My lord, my apprehension is that, my lord, based on a legally flawed inquiry report, my lord, they may proceed to impose a penalty. Now, I am chary of that, my lord. There has been a violation of the rules at every stage of the so-called proceedings, my lord.
Lordship may issue notice, fix it after 2 weeks, let me take the instruction first, lordship.
Till then, my lord, let there be a stay, my lord.
Nothing has happened, please, no interim order may be given, lordship, at this stage.
My representation, my lord, is very details the various flaws, my lord, the deviations from the rule. Rule 9, my lord, is mandatory, my lord, and the non-compliance we will vitiate the proceedings, my lord.
Okay, heard Mr. T.N. Srinivasan, does it count? By this writ petition, the petitioner is challenging the inquiry report dated
24/7/23, my lord.
24/7.
No, my lord, it will be. My lord, I'm sorry, my lord, it's 2/8/23, my lord.
Where can I find the date?
That, my lord, page 29, my lord. And it's a
The
G.
inquiry report dated 2/8/2023. On the ground that the departmental inquiry was conducted in violation of Rule 9 of the Assam Services within bracket Discipline and Appeal Rules 1964. Stop. The petitioner further alleges that no presenting officer was appointed and the said inquiry is not an inquiry in the eye of law. Accordingly, issue notice. Mr. SMT Chief, the understanding council,
Lordship, here is a secondary education for 1, 2, and 3.
secondary education.
Respondent 1,
appears
2,
for
and
the
3.
Respondents 1, 2, and 3.
4 and 5 are registered for.
The petitioner takes steps for service of notice on the respond number 4 and 5 by registered post within 1 week. List the matter after 4 weeks. Till the next available date, no coercive action shall be taken against the petitioner. Pursuant to the inquiry report dated 2/8.
I'm obliged, my lord.
11.
Petitioner before your lordship, my lord, is agreed, my lord, by an order, my lord, issued by the Secretary School Education Department, my lord, at page 27, my lord.
Page
27, my lord. This was passed, my lord, in pursuant to the, my lord, court's order, my lord, dated 26/6/2022, passed in WBC number 4733. My lord, here, my lord. Now, my lord, what happened, my lord, in this case, my lord, petitioner, my lord, was initially appointed as an assistant teacher, my lord. On
What is the
19.
order of 26/6/2022 of this court?
My lord, this court, my lord, kindly come to page
Yes.
21, my lord,
I've seen.
and 23, my lord, is the operative portion, my lord. It has directed, my lord, to submit and prepare an appeal under section 14, my lord,
Yes.
of the Act of 2017, my lord. Accordingly, that appeal was preferred, my lord, and in pursuant to that appeal, my lord, that passed that, my lord, the appeal is at page 25, my lord. In pursuant to that appeal, my lord, that passed this impugned order, my lord, page 27, my lord. Here, my lord, your lordship may kindly find, my lord, at paragraph 4, my lord. 4 onwards, my lord, it will clarify, my lord, how the petition was determined, my lord. Page 27, my lord, kindly see paragraph 4, my lord. Here, my lord, petitioner named Santosh Kori, my lord, was recommended by the district student committee as English teacher, my lord. Thereafter, my lord, as per instruction of the Office of the Director of Elementary Education, Assam, to all DOs for a submission of proposal as per provision laid down in the Act of 2017, the district student committee CASA recommended the following post for provincialization of service in respect of Dudh Patel Grant ME School and DO CASA. Now, Malakali C. Mokmudul Haq, Mala respondent number 6. He was recommended as social science teacher. Sarita Bhardas and Bengali teacher. And petitioner, my lord, his name was shown as maths and science teacher, my lord. Here, my lord, initially, my lord, district scrutiny committee had recommended his name as assistant teacher in English, my lord. Subsequently, my lord, his name was recommended as maths and science teacher, my lord. Thereafter, my lord, subsequently, the proposal was placed before the SLSC as well as the Joint Committee of GOV for recommendation, and it was found that in the earlier proposal, name of Purnab Kumar Chanda was enrolled against science and maths. But in the next proposal, the petitioner Santosh was recommended as maths and science teacher. Upon verification, it was seen that qualification of Purnab Kumar Chanda was BSc appeared, and Santosh Kumar was assistant teacher. Now, kindly please come to 28. Thereafter, SLSC as well as the Joint Committee of the Government recommended the following 3 teachers as tutors against Dudh Patel Grant ME School as per Provincialization Act 2017, maintaining the sequence of recommendation of DSC Mala Kasar. Here, Makani C. Mokmadul Haq Laskar, Mala respondent number 6, respondent 7, Sarita Bhardas, and Purnab Kumar Chanda, respondent number, he was not met party here, Mala. Here, Mala petitioner name was omitted, Mala. On Sarita Bhardas, Mala, her name was recommended, my lord, as Bengali language teacher in Bengali, my lord. Whereas, my lord, she was appointed in the 2007, my lord, and petitioner was appointed in the 1995, and his name was recommended, my lord, as English teacher, my lord. Now, my lord, the respondent number 7, my lord, Sarita Bhardas, her name was my lord, my lord. And on that basis, my lord, the petitioner's appeal was, my lord, rejected, my lord.
We'll have to issue notice.
My lord.
But Mr. S. have Learned Council for the petition. Issue notice. MS and Fukant, the standing council,
Correspondent 1, 2,
elementary education, affairs correspondence, 1,
3, and 5.
1, 3, and 5. Mr.
B duty.
D. Duril and a governor advocate.
Correspondent number.
Appears for the respond number 4. Stop. Petitioner to take steps for service of notice on the respondents 6 and 7 by registered within 1 week.
My lord.
Respondents are allowed to file their applications. List of the forms.
My lord. Obliged.
9.
But he was here.
So my lord, may I continue? So my lord, before my lord proceeds, my lord, I'd like to show this order of this Honorable High Court, my lord. This High Court, my lord, paragraph 26, my lord. Thanks, Mr. Chief.
My lord, before my learned friend starts, my lord, absolutely. It's on.
They're praying for some time, my lord.
I'm praying for some time, my lord, because the matter has been discussed at the appropriate level. The authorities are preparing instruction, my lord, maybe another 7 days time may be given.
My lord,
Where the interim order, she is already protected.
no, my lord, I'll just place it here, my lord. My lord has gone through the order I have placed, my lord. My lord, this was the happened on the last date, that is on 3/5/2024. There was a specific instruction was asked because the Honorable Court at the prima facie level has appreciated the fact that what has been done illegally. My lord, that is the order.
Have you corrected the error?
Yes, my lord, I have corrected the error. I've corrected. So, my lord, now what I pray before my lord is that the interim protection that was been given to me was no coercive action. I was asked to work in the Department of Trauma. But my lord, the page 135 or 135, my lord. The impugn order, my lord.
Yes.
My lord, this has to be stayed, my lord, because this is absolutely illegal. And because of this, the instruction was seek for. The line of the order of the last date has been very much clear that how can you do this? They are just trying to protect and candidate, my lord. And my lord,
Okay,
That would amount to a final order, my lord.
no,
Let
no,
the
this is
instruction
not about the
come
final order, my lord. My prayer is to my lord, I am a petitioner here. I can only pray to the authority that,
what is your prayer?
my lord, so she is setting aside the impugn order dated 4/4/2024, passed with the respondent number 5, the warning letters 22/11/2023, 17/4/2023, passed with respondent number 5. I have been issued warning letter by them.
for the
And remand back the matter before the appropriate disciplinary authority for fresh and due consideration of the inquiry report as per the schedule 2. This is my,
My lord, warning letter is concerned, she is already protected, my lord.
no, I am protected because I have to take protection.
So for
So,
four order is concerned, my lord, for that, my lord, without instruction, my lord, any stay would amount to a final order.
no, my lord, that would not amount to final order.
That is the main order, my lord.
No, no, my lord, that is not the amount to be final order, my lord. That is an illegality they have done.
Four order is the impugn order, my lord.
Okay, but Mr.
SP Sharma.
Mr. S. Gupta and CD submits that the respondents are having a discussion. at the
My lord,
appropriate-
before my lord passes an order, I just want to point one thing, my lord. My lord may, before passes the order, my lord may note here, the respondent number 6, because he has not been suspended or no action has been taken, he is a doctor of pediatrics. And he has been seeing patients, despite the fact that there has been a sexual harassment proven by the ICC. So that may be taken into account, my lord, before my lord passes an order.
No, that's fine. We'll see what instructions they come.
Yes, my lord.
That the matter is being discussed at the appropriate level. And therefore, place for a week's time,
My lord, a week's time.
place for a week's
Notice
time.
will be issued, my lord. Notice has not been issued.
You want notice to go?
Yes, my lord, notice has to be go because the lord.
Then notice has to go on the private respondent, isn't it?
Yes, my lord, that will be better, my lord.
I've already filed my Bharat. May I just?
Okay, 1 minute. Then cancel the order. Let's start with SP Sharma, then we'll call this. Issue not. Mr. H. Gupta, then the CEC. Appears on behalf of
Lord, 1 to 5, my lord,
1,
1 to 5 and my lord,
1 to 5.
and 7 and 8, my lord.
5 is by person,
By perspective, sorry, my lord. 1 to 4
1 to 4.
and 7 and 8, my lord.
And 7 and 8. Stop. Mr. R.B. Fukan. R.B. Fukan for 6. The Honorable Council appears for the response number 6. Stop. Petitioner to take steps for service of notice for response number 5 by registered post daily in the one.
No, but it's independent body, no?
Stop. Is the matter of the interim order procedure to continue in the next week.
No, my lord, I think for respondent number 4, it's an independent body, my lord. So, because it's an internal committee under the POSH Act. So I think my learned friend cannot appear for respondent number 4 here.
4 and 7, my lord, then in that case, notice may go.
4 and 7 notice has to go, my lord.
Okay, then each on top say appears for respondents 1, 2, 3,
Only 1, 2, 3.
and 8.
8,
Correct.
yes, 1.
1, 2, 3, and 8.
Yes.
And Mr. So then council appears for respondent number 6.
6 months.
6. Petitioner to take steps for service of notice
4, 5,
on the respondent 4, 5,
and 7.
and 7 by registered post within 1 day. Is the matter of the forwards. Interim order procedure to continue in the next session.
My lord, this order of page number 35 may be stayed, my lord. 135.
There's no point.
My lord, because that is, because of this
Now
order,
you are under protection, no coercive steps be taken.
my lord. What's up, my lord?
12, the vacating applicant.
Yes.
Lordship, may I please to take up the IA, Lordship. IA 6559 of 2020.
I know. You file your objection?
Yes, Lordship, they have file objection, Lordship.
Yes.
So this IA is filed for modification of order dated 11/8 that Lordship will find at page 18 of the IA, Lordship. 11th of August 2023. Whereby your Lordship was pleased to stay the order dated 25/7/2023. And this, by this order, Lordship, 25th of,
Where is that order?
yes, that Lordship will find at page 93 of the writ petition.
93.
93.
Petition.
Yes, writ petition. This order is, Lordship, issued by the director in compliance of the earlier round of litigation filed by the petitioner, challenging the the recommendation of the district scrutiny committee. But ultimately by this order 25th of July 2023, page 93, the claim of the petitioner is rejected after hearing all the parties' Lordship and consideration of the all necessary documents. If you go by the page 94, the order, Lordship, from, may I read, Lordship, page
Yes.
94? From the above facts and circumstances, it is seen that District Scrutiny Committee, Dhubri, under clause 13(6) of the Act 2017, was not recommended the name of the petitioner, Alapuddin Ahmed, for provincialization of service. Also, the District Scrutiny Committee resolved by minutes dated 29 so-and-so that in case of headmaster of UP school recommended having more than 100 enrollments in the institution. On the other hand, the District Scrutiny Committee Dhubri recommended 3 numbers of teachers under the clause 3(1)(11) of the Act. And after verification of the documents, the state level selection committee as well as joint committee could not recommended the name of the petitioner Alapuddin Ahmed for provincialization of service against so-and-so school as per the Act 17. Hence, the claim of the petitioner for provincialization of service cannot be considered and hereby rejected. So ultimately, when challenging this petition, also he approached this court and he, by your lordship's order, this order is stayed. Now in the IA, now lordship take up the IA. In the IA lordship, I have filed certain documents. His claim is that the grievance of the petitioner is that he is the senior most teacher. He is teaching social science. So the service of the petitioner is ought to be provincialized in place of the respondent number 7. But the record reveals, I have annexed lordship, I am coming to the lordship, that since 2006 to 2015, the petitioner neither serving as an assistant teacher or headmaster, nor a headmaster in that particular school. Now we will also come to the IA. So for the annexer 1 and 2, 1 is the order, B is the appointment and joining order. Now prior to provincialization, this school has been inspected. I have enclosed the inspection report of the school. And during inspection, the lordship will find at page 21, annexer, sorry, page 20, annexer C. This is the joining report. And this is the first inquiry report, page 21. Now, prior to provincialization, when the school was lordship, in the Fensar state lordship, this school has been inspected from time to time. So I have enclosed 2-3 lordship inquiry report. And during inspection lordship, this petitioner was not found that he is working in that particular school. So that is why I annexed all these documents to show that this.
What is the name of the petitioner?
Name of the petitioner is Alapuddin Ahmed. The first report of 2009, his claim is that since 1991, he is serving in the school. But my contention is that, yes, I am appointed in 2008. At least since 2008, I have never seen this petitioner is serving in my school. So, lordship, to substantiate my claim, I have annexed this certain documents. Now, from the inquiry report of 2009, it shows that petitioner's name is not found as a working teacher. Similarly, annexer E, they also not found the petitioner's name, lordship. Annexer E, page 22, type copy of 2009. The name, the last 3 months daily average students so and so. The name of the teacher's lordship, Azizul Rabiul Noor. But the name of the petitioner is Alapuddin Ahmed. He is not found in the school.
Your name appears at serial number?
Also here also after I have been appointed in 2008. And my name is reflected in the DIAS report submitted by the SSA lordship. I have enclosed those documents also. My initial appointment was of March 2008.
Page.
This is the annexer B, page 19. This is the first appointment order, 9/3/2008. As per resolution adopted by the school authority, I've been appointed. And thereafter I've joined. My joining report letter is at annexer C. Is accepted by the headmaster on 13th of March 2018. So since 2008 of March 2008, I've been continuing serving in the school. Now let's come to the DIAS report. The schools is captured under the DIAS data which is maintained by the SSA lordship since 2006 till date. But the petitioner's lordship annexed some of the relevant lordship DIAS report to show whether the petitioner is serving in the school or not. Now let's come to annexer F, page 33. This was the first DIAS report of 2006 and 2007. His all along claim is that he is serving in the school since 1991. So far the respondent 7 is concerned, at least since 2008, on the date of appointment of the respondent number 7, the petitioner is not serving in the capacity of headmaster as well as lordship the assistant teacher. And this report of Dias and the attendance register of the school, it demonstrates that yes, the petitioner is not serving in the school. Now we will also come to page 30, annexure page 23, annexure F. This was the report of Dias report of 2006 and 2007. Now Dias report actually what is, it shows that the particulars of school lordship and the name of the serving teachers along with the number of students lordship. Now if you go by the name of the teachers, you will also come to serial number 1 to 5. At least the name of the petitioner should be incorporated in the Dias report. But the report says the petitioner's name is not found, to meaning thereby he is not serving that particular school lordship at that relevant point of time. So this is the report of 2006 and 7. Similarly, I have annexed the documents of 2007 and 8. This also shows the petitioner's name is not found. Sam Hafizur Rahman, serial number 1, page 24. He is serving as a headmaster of that particular school. Similarly, page 25, this is the report of 2009 and 10, which is the mandatory requirement as per the Act of this 2017 to provincialize or to take up a particular institutions for provincialization. The name of the teachers should be captured at least for the year 2009 and 10. Now, if we go by the report of this data of 2009 and 10, here also the name of the petitioner does not figure. So similarly, 2010, 11, 11, 12, I have annexed this Dias report where lordship, the name of the petitioner is not found. But so far the respondent number 7 is concerned, his name is lordship incorporated. If you go by the Dias report of 2019, the lordship last serial number Hatem Ali Khan. This is the respondent number 7. Lordship got it, page 25. Last name lordship Hatem Ali Khan. So meaning thereby he is serving in that particular school. So as a result, his name is incorporated in the Dias report. So with effect from 2009 and 10 lordship, which is the mandatory requirement for provincialization of a school as well as the serving teachers lordship, the name is captured under the Dias report. Yeah. Then petitioner also lordship annex the teacher attendance report at least from 2012 to 2015. Annexure Z lordship. For a particular year lordship, I have annexed the from the month of January up to the December. And this also says, the shows lordship, the name of the petitioner is not found anywhere lordship. Whether he is serving as a headmaster or lordship, assistant teacher of that particular school in question. So lordship, the petitioner or the respondent number 7 claim is that at least since 2008 to 2015 or 16, the petitioner is not serving in the school, number 1. And this shows the report of the Dias report as well as the teacher attendance report. It clearly demonstrates, yes, the petitioner is not serving in the particular school. Now, under the 2017 Act, the head of the institutions forwarded the particulars of serving teachers for provincialization. The page 36 annexure H, this is the individual information submitted by the teachers concerned, and this report ultimately forwarded by the head of the institutions to the member secretary for recommendation to for provincialization service. Now, annexure I and J, even if we go by this report only, this only shows that the petitioner's claim is for subject English. He is teaching English. This is his report. If we, for a moment, if we're discarding all the report of Dias report, teacher attendance register, the annexure I and J, This is the report prepared by the petitioner himself. This is the signature, Alapuddin Ahmed. Lordship, Annexer I, page 37. This is the report furnished by the headmaster concerned of the school before the concerned authority for initial recommendation. Now, if we go by this report of Annexer I and J, this also shows that the claim of the petitioner for the post of tutor in the social studies, this is wrong. The serial number 1, Annexer I, page 37, serial number 1, LF18 MA. Here, Lordship, name of subject taught, Lordship, column number 12, English. Lordship, got it, English. So far, the petitioner is concerned, serial number 3, Hatem Ali Khan, he is social science. This is his own report. And this report is prepared according to the teacher who is teaching this concerned subject. And in that particular year of 2017, there were 6 number of teachers who are serving at that relevant point of time and teaching all this concerned subject. Now, if we go by this report of the headmaster, this also shows that the teacher, the petitioner, is not a teacher of teaching social science. My claim is for social science. His claim is now that he is teaching all subjects, including the social science. But my service is recommended by the District Scrutiny Committee for the subject social studies. Now, Annexer J. This is the list of untrained in service teachers of government aided UP school. This is also report submitted by the petitioner himself. This also says serial number 1, the column number 13, English. So far, the petitioner is concerned, serial number 3. His subject is social science.
Yes.
So thereafter, also the District Scrutiny Committee, Annexer K, page 39. This recommended my name, page 40. The serial clause number 6, Lordship, details of the tutor eligible for provincialization. My name is Hatem Ali Khan, social science. Page 40, Lordship. And the column number 7, these are the name of teachers whose service is not eligible for provincialization. So for the petitioner, his name is also figured there. Alapuddin Ahmed. So ultimately, the authority, Lordship, recommended, but because of this staying of this order, Lordship, the consequence of order could not be passed by the authority. Now, one of the
Deka,
Lordship.
issue is, if I pass an order in this IA,
Yes.
it will have a bearing on the merits.
So Lordship, a final disposal, Lord.
Why can't we have a final disposal? Have you filed your affidavit in the writ?
Lordship, this IA can be treated as an affidavit, Lord.
Okay. Okay.
Because I have the next all the relevant documents. Lordship fix in a particular hearing there for final disposal, Lordship.
Okay.
Because otherwise also there is no use also for keeping pending this for long time. Ultimately, no one is benefited, neither me or Lordship nor he. But
Yes,
because of the what is just affidavit? Ultimately, the impugn order is there, Lordship.
Only the
The reason
thing
is cited.
you just produce the minutes of the District Scrutiny Committee. That's all.
The grievance of one of the claim is that there are 2 district scrutiny reports. The director, Lordship, relied on the district scrutiny report which is submitted by the response number 7. But so far the petitioner is concerned that the district scrutiny report or recommendation relied by the director in respect of the response number 7 is not genuine, Lordship. Because if you, Lordship, kindly go to page, Lordship, I have annexed that report. Annexer K, page 39. This is certified by the member secretary, the DO. DO is the member secretary of the District Scrutiny Committee. He certified this report as per the records available in the office of the DO. Now, the grievance of the petitioner is that This report is not, all the pages of the report is not signed. But the director lordship relied upon this report only, page 39. And this is certified by the member secretary of the district scrutiny committee. And even also from the own report of the petitioner, his claim is for social study. But his report shows that he is teaching English, is that subject language. But my claim is for social study. Even that on that count also lordship petitioner is not eligible.
May I submit my lord? Lord, in the writ petition, this is the second round of writ petition filed by the petitioner. Page 79 of the writ petition. Your lordship has earlier directed. Page 81, paragraph 5. From 86 onwards.
Page?
Order dated 79, order dated 9/8/2022. My first writ petition. Then your lordship at paragraph 5, page 81, held that there are two recommendations. One recommendation was made in my favor, and another recommendation was made in favor of the private respondent. Since I was appointed in the year 1991, and the private respondent was appointed in the year 2008, there is a huge difference of seniority, my lord.
But your name does not appear in the dice code.
Yes, my lord. Therefore, there are two recommendations. One recommendation page, my lord, your lordship, please to page 44. This is authenticate proposal for provincialization of service of, and my name reflected, page 46. This is a type copy, and page 48.
Page?
Page from page 44. This is the report submitted by the deputy commissioner to the director. Authenticate report proposal. Then page 48. Middle portion. Eligibility. Designation. My lord, then subject of social science. And this report was signed by all the members. Therefore, it was stated to be genuine. And another report was in favor of the private respondent, page 75. This is a communication made to the standing council by the director. In the first report also, my name has been recommended since I was appointed in the year 1991. This is signed by all the members. In respect of the private respondent, that page on that page, nobody has signed it. Page 77, where his name was reflected. All the members did not put their signature. Bottom portion.
That we'll see after we get the minutes of the district school.
And therefore, your lordship has directed that the director will consider both the report and consider which report is genuine and who is eligible for provincialization. But while passing the speaking order, the director has not referred to my report, only his report has been reflected. And therefore, your lordship has stated
okay. In the IA, you take down, hurt Mr. A. Dekan and the council for the applicant. Stop. Also hurt Mr. N. Sharma, then it's council for the opposite party number. One. And MS N. Kukan, then the standing council. Elementary Education Department. You are appealing for elementary?
Yes.
For respondents, 2, 3, 4, and 6. For the opposite party.
Minus 1, 2, 3, and 5 matter.
No. In the IA.
IA.
2, 3, 4, and 6.
Yeah.
1, 2, 3 matter.
Uh-huh.
5.
One is a writ petitioner.
Two is the two her, 3, 4, 5. ठीक है तो ऐसे ठीक है ये तो लो all right wait हाँ तो ठीक है all right
Not all,
no
not
5 to 8. Deputy Commissioner.
2, 3, 4, and 6.
Yes, yes.
And Mr. P. Dury, Leonard, Government Advocate for the response number 5. Stop.
yes 5
But after hearing the parties at length, this court is of the constituted opinion that if any order is passed in the present IA, it will have a bearing in the main writ petition. And accordingly, in the interest of justice, it would be appropriate to dispose of the main writ petition on merits. Stop. Accordingly, the present IA shall be treated as
affidavit
counter affidavit on behalf of the respondent number
7 lordship
7 in WBC number
petition number
4602
Yes.
of 2023. Stop. When do you want?
was it 21st of May lordship and there was to be made to dispose of it.
21st.
The hearing day, Lord.
There'll be some difficulty.
Then on a hearing the next lordship
28,
28 yes lord.
release the matter. This matter is on 28. Stop. MSN Fupan, the Standing Council, Elementary Education shall also produce the minutes of this district scrutiny committee.
Both the reports, otherwise it will take in one side. Page 44.
There will be only one report.
No, page 44. Same report.
So
In the report in my
is
paper.
the claim of the petitioner
As
that there are
rejected.
2 reports. From the director lordship there is 1 report. The report
only
relied
one
by the
report.
respondent 7.
You lordship was also observed in page 82. There are 2 reports.
Page
Page 82. In the repetition, from 81 last paragraph after paging of so and so, there are 2 recommendations of the district scrutiny committee. One which is annexed with the repetition and the other which is the letter written by the director with regard to the recommendation of both of us. So both the recommendations and the reports are necessary. The director has considered only one report, which was made in his favor, not in.
yes, shall produce the minutes of the district scrutiny committee. Where is that district scrutiny committee?
My lord,
It is
my page 44. Page 44 and another is page 75.
What date is this?
The report lordship date is not reflected.
Yeah.
Standing down. This is a standing letter communication subject to standing down. And my report page 44 is. that
Anyway, there'll be just one report. There may be no 2 reports. The district scrutiny committee.
Yes.
Stop. I said list down.
Interim order parcel.
Okay, interim order passing the main petition to continue till the next sitting.
Reply of knowledge.
13.
May I please, your lordship? My lord, I want to file an objection in this, my lord. I am not receiving some relevant documents. So kindly 1 week time may be granted now.
When were you served a copy?
My lord,
When was the copy of the present IA served upon you?
the matter was posted, my lord, in the last week, 1 week earlier.
20 February.
In the IA?
I am, my lord, the copy was served earlier, but the matter has been, my lord, first.
When did you serve? When was the copy served?
20 February lordship.
20
February lordship.
20 February.
Yes.
This is an application under Article 226,
Ma'am.
3.
Madam.
Then what happens now?
Malad, the matter was listed and my learner fate, Malad, for the first occasion listed perhaps it is 1 week back, Malad. But then my learner first on that day have taken an adjournment, Malad.
1 week back.
1 week,
This was listed on 3/5/2024.
3-5 months. 10 days, Malad. 7 days. 7 days,
That we'll have to consider. There are already rulings.
Malad.
Not from the date it was published, it was listed in the court.
Malad.
It will be from the date you
Yes,
receive the
ma'am.
copy. So automatically interim order stands vacated.
Malad.
Then what objections do you want to file?
No, Malad, then Malad, let them Malad make the submission. Malad, the earlier occasion, my learner phase is taken adjournment, Malad.
Maybe. But you are present, isn't it?
I was present.
You should have objected to the.
I have Malad objected. Well, but the court has Malad, he's not prepared. The time has been given, and Malad said that Malad within 10 days it has been fixed. There's no any fall on my part.
When do you want to file your objection?
Malad, Malad.
You can't say there's no fault on your part. You should have objected.
It is your lordship discretion. I'm Malad just receiving some documents Monday. Perhaps I will receive Malad.
Okay, heard, Mr.
D, sir, my lord.
Then the counsel for the applicant. Mr.
BK Dasman.
BK Das, then the stand, counsel for the opposite party number.
Writ petitioner, opposite party number 1.
Opposite party number 1, oblique writ petitioner. Praise for how much time you require?
Malad, 1 week.
1 week time to file objections. Praise allowed. List on 17th.
I live late.
Don't say list on 20.
14.
We have filed I-1 24/4, my lord, to vacate the interim order, my lord, ex parte interim order, my lord. And today morning, my lord, 10:45, the writ petitioner has filed objection, my lord. We have to file reply, my lord, against
The
the,
notice has not gone, isn't it?
on 24/4.
I am melody, I am.
IA.
Yeah.
Yes, my lord.
No notice has been issued.
Yes.
No, my lord.
We already filed affidavit, my lord. We already.
We have
the
hard
request,
copy on 24/4, my lord.
Heard, Mr.
M. Hussain, my lord.
M. Hussain, then the counsel for the applicant.
Yes, sir, Ahmed.
Mr. H.R. Ahmed, then the counsel applying for the respond number
1 to 10.
for the opposite party,
Number 1 to 10.
1 to 10.
Yes.
Submits that he has filed affidavit in opposition. In the present line. Mr. So and so, then the counsel for the applicant. Praise for how much time?
1 week, my lord.
Praise for a week's time to file reply. To file reply affidavit. Stop. To file rejoinder affidavit. Stop. Praise allowed. This matter, when do you want?
After 1 week, my lord. Any date.
We'll give a date. 20.
Intimator pass.
Not necessary, my lord.
Earlier intimator may continue. Why not
Interim
necessary?
order passed in the when
My lord, kindly see the interim order, my lord.
you have applied for vacation of the interim order. We have
But not
considered your
necessary,
idea.
my lord, not necessary to continue the interim order, my lord. Page 66 of my IA, my lord. Sixty-six, my lord, from bottom, my lord, first paragraph, accordingly, till the appeal as filed by the petition number 112/2014 is disposed of, the approval granted by the district elimination officer by his communication dated 5/1/2024 to the constitution of school managing committee shall be kept in abeyance. my lord.
When petition shall continue to the next.
Not necessary, my lord, to continue.
Obliged, my lord.
Obviously.
15 and 16, no step.
Yes, till now you have not taken steps.
But we'll take steps, not, but in
No,
the
no,
mean.
no, have you taken steps?
Just to learn anything.
On 7/2/2024, you're given 2 days time to take first steps on response.
Today itself, my lord, I will take steps, my lord. Let it be posted after a week, my lord. I will take steps today itself. my lord. Is it better?
You have an interim order in your favor?
Yes, there is an
I'll vacate that interim order.
my lord, that maybe, my lord, continue, my lord.
Because of the interim order, you are not taking steps.
It has somehow, my lord, left, my lord. I'll take it, my lord, today itself, my lord, positively.
In both the writ petitions,
Yes, my lord. Which means it was a conversion, so it was spoken. Well, okay.
Mr. M.U. Mondal and counsel for the petitioner. In WBC number 5045 of 2022. Submits that he'll be taking steps for service of notice on the respondents 5 and 6 by listed post dated within the course of a day. Accordingly, list this matter after 4 weeks.
After a week.
4 weeks.
Bless you. Nobody.
17, implement of party.
My lord, I am here for the repetition of it. One copy regarding implement of the petition as per number 5 has been served upon me. I take 2 weeks time to find the objection.
You want to file objection?
Yes.
My lord, you will also kindly see the nature of the case. Election was held. His candidature has been rejected because he was passed both SLC and higher secondary in the same year, my lord. On that ground, his candidature has been rejected. Allah this honorable pass an interim order. After receiving the instruction, that interim order has been vacated. Now, because of the pendency of the writ petition, the authority could not proceed for further appointment. But I came to London, I have been got selection. Because of the pendency of this writ petition, the earlier to that, my lord, he also filed another writ
You know,
petition
what is this implement for?
for respondent.
Which respondent?
Petitioner, this applicant.
Hmm.
And this applicant also participate in the selection process.
Okay,
Selection process.
okay.
And he came to London, he has been got selection. And the college authority recommended his name. Because of the earlier pass an interim order by this noble court,
Hmm.
and that was vacated. After receiving after receiving the notice, annexure 4, my lord, my IA. This noble court, after receiving the instruction, page 16, the Losser can receive.
Okay, anyway, he wants to file an.
Whatever is stated by me is not true, my lord.
No,
The order is very much there. In 5/1/2023, there is an order, my lord, whereby it is, my lord, lordship has observed under what provision, my lord, my rejection. They are saying that I passed the higher secondary and metric in the same year, and that is why I was asked to clarify on that issue. By this time, the lordship also pleased to pass an order that there is no any, my lord, impediment in, my lord, they appointing anybody, but that should be subject to the outcome of the writ petition. So, my lord, there is no any bar. And so far, my lord, he has filed the application. Nobody has been now till day, my lord, recommended by the selection committee, and that is not been forwarded to the DSC. As per the earlier occasion, the sending council applies to the court. So 2 weeks time may be granted, so I will file the affidavit.
Okay, hot, Mr.
Ahmed.
J. Ahmed, counsel for the.
Later, 7 days time again.
Issue notice.
3 weeks time.
Mr. P. Manda,
My lord.
Leonard. Counsel
What is the petitioner, my lord?
appears
Sir, opposite party
for
number one.
opposite party number one.
One.
Public
In I.
Mr. A.R. Davinda, Leonard, Standing Council Higher Education appears for respondents 2, 3 and 2 and 3. And Mr.
Appearing for respondent number 4, R is
DB.
and R. Islam, Leonard Council.
Five
appears
also.
for respondent
Five also.
5, 4 and 5. both.
Five also. Principal, same.
4 and 5. Director, 3 is the director.
Director is the same. Director is
Director আছে 2 and 3. 2 and 3.
2 and 3. No,
Oh,
I, boy,
2 and 3.
2 and 3.
Page 3. Mr. P. Manda, Leonard Council for the opposite party number 1.
1, my.
Public petitioner prays for 2 weeks time to file objections. Prays allowed. List of 2 weeks.
Mass of it.
18, admission.
Matter may be possible for time being lordship.
Why?
My senior and Lex lordship in court number 10 lordship.
My lord, in this matter, they have filed one additional affidavit on 8/5/2024, my lord. So sometime is required to us also, my lord.
8-5.
8/5/2024.
Let my senior come lordship.
Okay, let uh,
Let my
K.
senior
come.
come. Ma'am.
19.
Have you filed your affidavit, Furkan?
Lordship, we have not filed affidavit, my lord. We have basically written to we are awaiting instructions, your lordship. I've got the copy of the my lord communication, my lord.
Last order
So
says
some-
what?
My lord, to file our affidavit, we are awaiting, my lord, for some things. So, my lord, some time may be given to us. At least 10 days, my lord. We'll ensure that the affidavit is filed. We have written, my lord. The director has written to us for seeking some time, my lord, because it has written to the DEO Kachar. Wide office letter number.
Okay, none appears for the petitioner. Stop. Mr. A.
Furkan, my lord.
Learned Standing Council,
My lord, elementary education.
Elementary Education. Prays for 2 weeks time to enable him to file affidavit. Prays allowed. Leaks after 2 weeks.
20.
In this case, Lordship, Director, it is eliminated, they have filed their affidavit.
Mhm.
So Lordship may allow some time to file my reply.
Who is the affidavit?
Education Department.
We have filed an affidavit.
Response number 3.
You want to file reply to the.
I want some time to reply my file.
Okay, Mr.
H.
H.
Chetty.
Leonard Council for the petitioner. Prays for how much time?
2 weeks time.
Prays for 2 weeks time. To file reply to the affidavit in opposition filed by the respondent number 3. Stop. Prays allowed. List after 2 weeks.
Obliged.
21.
May I please, your lordship? My lord, in a division bench, my lord, in a retable, I've already directed for my promotion within 3 months. I'm the appellant number 5. And in this writ petition, I have, being a senior most, I paid for appointment on in charge basis, my lord. Now the division bench has already.
Here we have received the instruction.
Regular promotion. Why that
Which writ petition?
My lord, so
Read petition. Read petition. What is?
No, in view of this,
that may be disposed of because it is for regular promotion, my lord. That it
so this has become infractions.
is structure, so because it is for for in charge basis, my lord.
Okay,
Because I am the
Mr. SP,
government.
Laskar Learned Counsel for the petitioner submits that in view of the order dated 24/4/2024 passed by the Honorable Division Bench in writ appeal number 264 of 2022 and other batch of writ petitions. Comma, the matter has become infractious, correct? Mr.
PK Brown,
PK Boral, then Standing Counsel,
elementary education.
appeals for the Elementary Education Department. And Mr. S. Vishwa Karma, then Counsel, appeals for the response number 5. Writ petition is accordingly disposed
My
of.
lord, it has not become infracted. I'm thinking in terms of that order may be disposed of.
No, my lord, that is
Because
another.
it is for in charge, my lordship, and that is for regular promotion. Yes,
So,
because the honorable.
regular promotion, when you are going to get your regular.
Yes, yes,
promotion.
I recommend.
What is this? This.
This is for in charge, yes, because there was no
So when
regular.
you're
promotion.
paying for in charge, then becomes infractious. Isn't that?
He will get the regular.
You're getting regular promotion. Why are you pressing for in charge?
Yeah, yes.
You want to press for in charge?
No, no.
Accordingly, writ petition is disposed of as infractious.
Blessed. I love me.
May I please your lordship?
Uh.
Yeah, my lord, I have sent the affidavit for waiting, my lord, so pending 1 week time may be allowed, my lord.
Earlier also they took time.
Last time also you took
My
time.
lord, already I have sent it, my lord.
Either today, third, fourth date.
Last chance.
My lord.
But Mr. R. Rashid, A. Rashid, Learned Counsel for the MS N. Fukan, and Standing Counsel, Elementary Education Department. Is allowed another 1 week time
Kindly fixing a date, my lord.
as last chance to file contract. List on 29th.
23.
Please, lordship. Well, matter contrast, my lord, non-sanction of special family pension, my lord. Petitioner's husband, my lord, was killed by the extremist, my lord. And this honorable court had earlier occasion, my lord, by the judgment, my lord. They sanctioned directed the respondent to sanction the special family pension, my lord.
What is this?
Judgment, my lord, lordship will find, my lord. Page 21, my lord. Operative portion will find, my lord, page 31, my lord.
Yes.
Page 13, my lord. Remember hence it is directed the respondent in the education department as well as the pension department and other concerned authority in the state government shall compute the payment towards the special family pension due to the petitioner from date on which the same has become due to her, that is on the on and from the date following the date of her death of her husband, and shall pay the same after determining the difference between the special family pension to be paid to her and normal family pension that was awarded to her in the meantime. The entire amount towards her special pension will be paid to the petitioner by the respondent within a period of 6 months from date of this order, and the current special family pension will be paid to the within a period of 3 months from the date of this order. Failing which, both the amount will carry interest at the present rate of interest of the nationalized bank per annum. Well, although this judgment was communicated, but they did not comply. Subsequently, contempt case was filed, and in that contempt case, in purported compliance of the judgment, they had issued a corrigendum, only changed the name from family pension to special family pension, no financial benefit. The corrigendum is page 35. This is nothing, my lord. The earlier petitioner is still doing her normal family pension, my lord. And although, my lord, they have been petitioner has been communicating several occasions, my lord, for granting family, special family pension. Nothing they have not turned on, my lord. And page 39, you lordship will find, my lord, the present status of his pension, my lord. The amount, my lord, he is currently drawing, my lord, 8,952, my lord. Whereas, my lord, her husband's, my lord, who are the police of her husband, my lord, they are doing their salaries presently, my lord, at least 60 to 70,000, my lord. And the special family pension is, my lord, the actual salary, my lord. Now, my lord, the director of pension, my lord, had earlier several occasions, my lord, has directed to file affidavit as well as instructions, my lord. Not yet come, my lord.
Yes,
Director pension is the main authority, my lord.
what is this?
Lordship, we have, file has not come, your lordship. So, regarding the appointments, lordship may grant me 2 weeks' time. I shall file the necessary affidavit for that next day.
Last occasion, my lord, last.
But Mr. S. Haq, Learned Counsel for the petitioner. Mr. B. Deori, Learned Standing Counsel, Learned Government Advocate, appearing for the response number.
Director pension, my lord, respondent number, director pension is 4, my lord. 4. 4 and 5 also, no?
4, your lordship.
I will call
Is allowed 2 weeks time to file for the. Which up to 2 weeks.
last chance, my lord.
That we'll see, let them come with them.
My lord, that is the third round of litigation, my lord. My lord. A date has been fixed, my lord.
May.
My lord. Obligement.
But in this case, my lord, the elementary education department is supposed to file their affidavit, my lord. They have taken-
Somebody has filed it. A private respondent has filed.
Respondent number 4.
That is not material, my lord, in the, unless the.
Respondent
government
number
filed
4
the-
in 2571 and respondent number 7 in 3718. We have filed our affidavit. lordship. private-
Affidavit of the private respondent comes
It's a
subsequently, my lord.
matter relating to promotion. We were senior and qualified, but we are not considered.
Yes, who appears for the
This submission is continuing for last 1 year.
and who appears for the SCRT? Action is by the Department of. Oh. Okay.
My lord, record may be called for, my lord, if they do not file the affidavit, my lord.
Learned Counsel for the petitioner. And myself, Okan, Learned Standing Counsels, Elementary Education Department. Press for how much time?
2 weeks time.
2 weeks time to file up.
A date may be given.
If no affidavit is filed by the next suitable date, Learned Standing Council School Education shall produce the records.
A date may be given.
This the matter on 30 May.
27.
May it please your lordship. My lord, the petitioners before your lordship have approached this honorable court for the second time, my lord. Earlier, my lord, this honorable court was pleased to pass an order that my lord find at page 23. Her 11 portion is 24. And my lord, the petitioner, were my lord, the founder, grade 4 employee of a high school, my lord. The school was, while it was venture and subsequently the school was provincialized. The services of the non-teaching staffs have been provincialized, while the services of the petitioners were not provincialized. And therefore, the petitioners were asked to submit the particulars, and accordingly, particulars have been submitted, and that there was no consideration on the same. And thereafter, he approved this honorable court, my lord. By this two order, my lord, the direction is given to consider the case of the petitioners, my lord.
After that, what order was passed?
Then subsequently, my lord, order has been passed that my lord will find at page 31, my lord. Saying that, my lord, that although, my lord, since the petitioners were appointed as venture, grade 4 employee, that has been admitted, but only difficulty that was expressed in the impugn order is this, that the 2011 Act was abolished by this honorable court, and subsequently 2017 Act came. And because of that, their service could not be regularized. That was the cause shown. And our stand is this, my lord, since the teaching staff of the venture schools, my lord, under the 2011 Acts have been provincialized, have already been provincialized after, my lord, the order has been reviewed by this honorable court, that the state filed a review petition, my lord, wherein it has been stated that those employees have been already been benefit has already been given under the 2011 Act, my lord. Their service should not be touched, or benefit should be given to this, my lord. So on this limited aspect, my lord, in last occasion, my lord, the direction is given to file an affidavit, my lord, by the respondent side.
Yes,
My lord. My lord, in this method, here, my lord, in the order itself, it is stated that the government of Assam provincialized the school of the
So you
petitioner.
are not
along
filing
with
affidavit?
2011.
No, my lord.
you are not filing affidavit.
Yes, my lord.
You will not file.
My lord, we will file, my lord. My lord.
That's what I'm asking you. Whether
Yes,
you want to
yes,
file
yes,
affidavit
my
or
lord,
not?
we will file.
What, Mr.
M.H. Chaudhary.
M.A. Chowdhury, learned counsel for the petitioner. Mr. U. Sharma, learned standing counsel. Secondary
Education Department.
Praise for
Few weeks time, man.
2 weeks time to file contract. Praise the Lord. List of the
I leave list.
2 weeks.
28.
Lordship, matter partings, petitioners are represented through their represented for Karimganj district Anusuchit Jati Parishad, your lordship. The main grievance of the petitioner is that this is the fourth round of litigation before the honorable court. The petitioners in the year 1991 and 92, a scheme was adopted by the WPT and DC department to provide an amount of your lordship 10,34,000 to be distributed for payment as stipend to the 94 numbers of teachers who are supposed to be at that time to be appointed for educational upliftment and all these things, lordship, as per the scheme taken by the government. Now, the petitioners were the beneficiaries as per annexure 1 of the writ petition, your lordship. Now, at certain point of time, after when the appointments, all the appointments were done, the petitioner association gone to the district elementary education officer and they got a list where they have found that out of 94 teachers, only 10 numbers of people who belongs to the SC community were appointed, and the rest 84 numbers of teachers were not from the non-SC category, your lordship. Now, out of with that facing all these illegalities, your lordship, they have filed one civil one writ petition numbered civil rule number 1221 of 1993, your lordship. Annexure, your lordship, lordship, annexure 2, page 29.
Here, your lordship, after perusal of and after hearing this honorable court, your lordship may kindly peruse page number 30 of the writ petition, your lordship.
Yes.
There is a the direction that given by this honorable court.
Page 30.
Yes, your lordship. On 13th line, your lordship, of the page 30, your lordship. In the middle part, your lordship. Page 30 at the 13th line, your lordship.
Where's the original copy?
With the original copy, as it is an old pending, it was an old case I could not avail, and it was a part of the record of the earlier repetitions, your lordship.
Oh.
Of the 90. I could not get that. If your lordship allows me, I can file an additional affidavit by taking that copy, if your lordship asks me to do that. It was a part of the record of the earlier cases also, lordship. As such, I direct the authorities not to distribute any fund out of that fund, your lordship, as per the scheme, to non-scheduled category stipendiary school teachers, which are allocated only for the scheduled caste as stipendiary teachers only. And now with that finding, this honorable court disposed of that writ petition, your lordship. Now after that, your lordship, the president of the association, along with the president of the association, submitted a memorandum praying for to follow up the direction given by this honorable court. As per Annexure 3, lordship, page 31.
Anyway, what happened after that?
Ultimately, lordship, in the year 2022, an order has been passed by this honorable court at page 50, your lordship. The WPT and BC department were given the direction by this honorable court to avail the petitioner association list of persons who were the original beneficiaries of the amount of rupees so and so, your lordship. So my prayer is that, your lordship, thereafter we have submitted 2 or 3 representations also, but till to date nothing. In fact, from the year 1993, your lordship, until to date, we have not we are not provided with any relief till to date.
Were you given the list?
No, lordship, not yet, your lordship. We have submitted 2 or 3 at the last part. Annexure 12, your lordship, starts from page 53, 52, your lordship, after the judgment of this honorable court. But till to date, we have not provided with the list, your lordship.
Who appears for WBT?
Separate spending of Ardmore is there.
Pauline.
Lordship, can it be taken up after some time, your lordship permits? I have a matter in court number 17, lordship. So at 2, your lordship, I am requesting your lordship.
Why at 2?
Because there is a matter, stay matter in court number 17, your lordship, of urgent nature, your lordship, and I am all alone today before in this court, your lordship. So can it be taken at 2, your lordship?
Which court has to take precedence?
I have understood. So I have understood, your lordship. Extremely sorry, your lordship.
Yes.
WPT department name is not shown in the causeries also, my lord. That's why he is.
Start copy, your lordship, as per
Maybe,
your
my lord.
lordship direction.
My lord may take up some other day, my lord, showing their names, my lord.
Otherwise, we can dispose of this matter,
My-
directing the WBT department.
That has already been done in the year 2020.
No. Directing them to give the list.
Yes,
You
sir.
have not got the list, isn't it?
Not
So
yet.
without getting the list, you're not in a position to take any steps.
Yes, your
Correct.
lordship. Yes, your lordship.
So let them give you the list within a period of 1 week, 2 weeks.
That may also.
Where's Dhar?
After some time, my lord.
Okay,
After
at 2.
Much obliged.
Told Dhar. At 2 o'clock.
$33.
My lord, this matter can be disposed of on the similar line by disposed of by other two cases will dispose of, my lord. I'm giving the judgment by 214 bench. Very good. Very good. It is done. Yes, yes. Exactly same matter, my lord. On the same line it will dispose of. Two courts want to dispose of this. Two matters on the same line. All the details on the disposal.
What if the SCRT will be necessary party here?
Who applies for the SCRT?
What if Mr. P. Gogoi? P. Gogoi or S. Bora?
Call him.
You Google Guru? I can go to.
So you're operating a study center.
Now we are not agreeing. No, now no more, my lord. No, it was term appointment, my lord. Up to 2021. I see. I see. You know?
With your lordship. Mr. P. Gogoi, standing counsel SCRT is on legs on another court, my lord. We have received our paragraphs comments, my lord.
I'm praying for 2 weeks time to file our affidavit, my lord.
Can we dispose of on this line? Is what we are saying. There's no
Then
point of
the
keeping
other
this
two cases
issue
dispose of.
pending.
For the two coordinate bench.
My lord, may I please to pass over the matter for timing, my lord.
No, I'll be out. There's one paisa.
Mr. B. Gogoi is on legs, my lord.
After some time,
My lord.
Well, I'll be leaving out station now, well. Then let it be on Monday or.
then let Adhikari be there. If you're going to pass the order on the same line,
Yes, same line.
then we can dispose it off.
Yes.
Otherwise, we can give them time.
Yes.
Let us
My
see
lord,
what Gogoi says
Yes, my lord.
after some time.
Hello.
34.
May it please your lordship. My lord, in this case, the petitioner before your lordship is the senior most teacher of a higher secondary school, my lord. And my lord, he ought to have been given in charge of the principal as the regular principal has retired. And thereafter, my lord, he was not given the charge and charge was given to the inspector of the schools, my lord, by the impugn order, and that impugn order is under challenge. And in the first day, my lord, will find the first day some observation has been made that, my lord, the order dated, my lord, 11, my lord,
No, 13/3.
13/3, 2024, my lord, the first order.
Page,
My lord, in the first order in the order sheet, my lord.
oh, 13/3.
My lord.
Yes, 13/3.
In fact, my lord, only my lord, observation has been made that the MA degree obtained by the petitioner without permission of the competent authority. That is the only point taken. And because of that point, his candidature was rejected. And on this point, this honorable court has already held that if any degree is obtained from a university, my lord, and if the degree is otherwise valid, then the third party cannot come and say, challenge the degree.
Where's your suspension order?
Suspension order, but the suspension order is not the question here. In charge seat, my lord.
No, 1 minute. Where's the suspension order?
Well, the suspension order has not been annexed here, my lord. The suspension order, my lord, that was passed in 2015.
2015.
2015, and it has already been, my lord, reinstated, my lord.
When did you obtain your MA?
MA, my lord, in 2000, my lord.
2007.
My lord, 2017. 2007, that my lord will find at page 20, my lord. Page 20.
Information 2017, I think. It's a 2017.
Page 20, because he is having double MA, my lord, MA in Hindi and MA in political science. So MA in Hindi at page 20 and MA in, my lord, MA in political science at page 20, my lord. And my lord, Hindi MA, my lord, that page 21.
When were you reinstated?
My lord, reinstated, my lord. My lord, that my lord will find at page 28, my lord. That was the certificate given by the principal, my lord. He was reinstated on 27/3/2018, my lord. Page 28, my lord. period কিমান লৈকে কিমান period কিমানলৈকে কোন তাৰিখৰ পৰা কোন তাৰিখলৈ কোন তাৰিখৰ পৰা কোন তাৰিখলৈ
So you obtained your MA when you were under suspension?
my lord.
Can you do that?
My lord, that is the point, my lord, because during that period, 3 years period, my lord, I was under suspension, so I have taken degree during that period. Now question arises regarding permission, taking permission of the authority, my lord, whether I have taken,
That's why this court was asking you
my lord,
the suspension orders.
lord.
Suspension order there must be some requirements in the suspension order,
my lord,
which may say that you are not to leave the station.
my lord,
If you are
So-
not supposed to leave the station,
my lord.
then you could not have taken a
My lord, in last
MA degree
occasion,
from some other universities.
my lord, in last occasion, my lord, that query has been made, whether I have taken permission from the competent authority while I was pursuing MA, my lord. The instruction is this, my lord, I have not taken. That's, my lord, clearly I can submit, my lord, I have not taken in permission from the competent authority, and my lords, subsequently, my lord, I have gone through that for during suspension period, whether a permission is required or not required, my lord, there is no specific law subject to correction, my lord. I have gone through.
No,
and
let
over
us see your suspension order.
suspension order, of course, I have not annexed here, my lord.
You get a copy, we'll see.
Copy to nahi. So can I get on Monday, my lord?
Yes. Mr. M.H. Chowdhury, Learned Senior Counsel. Appearing for the petitioner. Shall produce a copy of the suspension order of the petitioner dated 5/8/2015. As well as the order dated 27/3/2018, by which the petitioner was reinstated back into service. 2 orders.
Right.
When do you want?
Monday or Tuesday, my lord?
List the matter on 14th.
Highly obliged.
35.
In this case, I am praying for 3 weeks time, Lordship. I have already received instruction. I'll find it.
Lordship, in that case, interim order passed on 19/3 may continue.
Kindly produce the last order, madam, 24/2024.
Yes. Right, private.
And also directed the British authority to place before this honorable court that who is in charge at present, madam.
Yes.
Lordship, I am holding the charts.
Yes.
And I have also filed affidavit to that regard. And perhaps the standing counsel BTC can also certify that part.
Yes, as per my instruction dated 6th May, Lordship, I'm directed that petitioner Runumi Priya DC in case of functioning the Borkola High School, Udalguri as in-charge headmistress, and the private respondent number 7, Tapashiri Boro, newly promoted headmistress on 13/3/24 in the said school is not functioning as headmistress of the school as per honorable court's order.
And kindly produce my affidavit in opposition filed by the respondent number 7. Page number 49. It is my joining report. Page 48 is the promotion order. And thereafter, page number 14 and thereafter on.
But then the authorities are saying that you are not functioning.
That is on record, my lord.
As per court's order, he was promoted, but in terms of the court's
In
order,
terms of the court's order,
Status quo was given, Lordship.
status quo order,
Status quo was given, my lord, not in favor of the petitioner, my lord. only status quo is saying that my lord, who is in church at present. He may be continue, my lord. But now,
She is in church, Lord. Petitioner is in church.
page number 25 of the read petition. Kindly produce, my lord.
Status quo order says who is holding the charge of headmistress.
Lordship.
When the order was passed, petitioner was holding.
19th. And I have joined on 15th.
Anyway. Since
Make up
Naya
three.
wants to file your affidavit, heard Mr.
Dr. A to read, Lord.
Dr. A.
Toti.
Doti, learned counsel for the petitioner. Stop. Mr. P. Nayak, learned standing counsel.
BTC, Lord.
PTC submits that he has received instructions and prays for how much time?
3 weeks, Lord.
3 weeks time to file affidavit. Praise allowed, list after 3 weeks. Interim order pass earlier to continue till the next interim.
At least the salary, my lord, that may be released, my lord. Because I have joined in service, my lord, on 15th. Thereafter, status quo is maintained on 19th. Meaning
You
thereby,
file-
I am
you file
already
an-
in charge, my lord.
You file an IA.
My lord.
Much of it. Status quo has been extended, Lordship. Status quo extended.
Interim order pass earlier to continue.
Much of it.
36.
His lordship, actually on last occasion notice was issued, department supposed to file affidavit, lordship.
Yes, you Sharma.
Evident, my lord, and moreover, my lord, SSC is required here. Mission director. Yes, na? Eight.
Become Chaudhary the cleaning manner. Let it come after. In the meantime, he'll file a affidavit, my lord.
Heard Mr.
NZ Chaudhary.
NZ
Chaudhary.
Chaudhary learned counsel for the petition. Mr. E. Sharma, learned standing counsel, Secretary Education Department. As well as Mr. S. Bora,
B. Chaudhary's name be reflected, my lord.
as well as Mr. B. Chowdhury, learned standing counsel assistant. Press for 3 weeks time to file their respective affidavits. Press allowed. List after 3 weeks.
Much obliged.
33.
Here I've got a detailed paragraph comment. I prefer 10 days time to file my affidavit.
They're saying this case is covered by the court.
Some materials are there, my lord. I'd like to file one affidavit.
The final.
But learned counsel for the petition.
33.
Mr. P. Gogoi, learned standing
SCRT, my
counsel.
lord. SCRT.
SCRT submits that he has received instructions and press for how much time?
After 10 days, my lord.
Press for 2 weeks time to file affidavit. Press allowed, list up to 2 weeks.
All right.
38. Order.
Nawazullah appear for
Office note. Steps has been taken on phone number six. And steps has been office
needed
note.
to night work up.
That's all.
Nawazullah to appear for
Order appear. And where is the caveat by the phone number thing?
Yes, have we taken steps?
2524, there is office note. 2524, there is office note.
2-5. There's no office note of 2-5.
In the IM,
I'm on the IA. Only 6-3-2024.
They have to
It
take
is
their
only-
steps on a private respondent, your lordship.
That was on 6/3/2024.
Yes, madam. Thereafter, the office note, madam, handwritten.
And return,
Yes, office note.
where? Okay. Okay, yeah. 2/5/24.
And I have also found that there is a caveat. But no private respondent.
Have you taken steps?
My lord, that is not confirmed, my lord, as
Not confirmed, then I'm dismissing this with.
my lord, as it is a long back, my lord, so I do not done
What
for the
long back?
record.
This is an order of 2/5/2024.
2/5.
You are not checking up your,
Not-
you're just coming and
Sorry,
appealing
my
for
lord.
nothing without doing your homework.
Sorry, my lord, and I will take a step.
Within 2 days, you take steps.
My lord.
Yes. Mr.
M. Hussain.
M. Hussain, learned counsel for the petition. For the applicant. Shall take steps. For service of notice. On the respond number 6. Within a period of 3 days from today. Okay, within a period of 1 week from today. Stop. And what do they use? Shall take steps for service of notice on respond number 6 by registered post ID. Within a period of 1 week from today. In the event if no steps are taken. Within the time limit prescribed by this court. This I shall stand dismissed without any further reference to this, without any further reference to the court. Stop. List the matter after 4 weeks.
Okay.
39.
Contempt.
Well, normally, I leave contempt matters to the young colleagues, but this is a matter of a really sad state of affairs. Your lordship will kindly come to the judgment, which your lordship will find at page 29. It's a judgment passed on 29, no?
Yes,
Page 37 onwards, the judgment starts. It's a judgment of 17th of November 2021. And the operative portion, your lordship will find at para 12 onwards, at page 39. From both points of view, the undated notification of the Commissioner and Secretary to the Government of Assam in the Secondary Education Department, which finds place at page 120, annexure so-and-so to the writ petition, is unsustainable in law. Accordingly, the same is set aside as there is already a cabinet decision dated 28/2/2016 for regularizing the services of the petitioners, and for the purpose of the office memorandum dated 2/3/2016 had been issued by the Principal Secretary to the Government of Assam in the Secondary Education Department. The respondents are now directed to carry forward and bring the said process to its logical end at the earliest. We have taken note that in the meantime, some of the petitioners are approaching the date of retirement in the month of December 2021. From such point of view, the requirement of bringing the process to its logical end be done positively within November 2021, so that if any benefits accrue to the petitioners, even the persons who would retire by December 21, may have the benefit of regularization.
at least for a few days prior to the retirement. These were the circumstances in which the direction was issued, and it is yet to be complied with. More than 2.5 years have passed. And a very strange kind of a stand is being taken. What had happened was, these were teachers who were left out, about 53 odd teachers. So a cabinet decision was taken that since other similarly placed people have already been regularized, they also should be regularized. Pursuant to the cabinet decision, there was an executive instruction issued that they will be regularized. It was not being done. Ultimately, some commissioner joins later and he tries to overturn the cabinet decision. That was challenged. That is what was interfered with. And this is the direction issued by this Honorable Court. And it is yet to see the light of day. And very strange kind of
I appear for the respondent number 5.
Post respondent 5.
The present secretary to the Department of Education, Government of Assam, Department of School Education. But
You directed to
what has happened?
bring this logical end
Yes,
by November 2021, correct?
yes.
Then
My lord, what has happened is the time frame given by this Honorable Court expired sometime in the year November 2021. The present secretary has joined his post, I have stated on affidavit, on the 2nd of February 2023. Nearly, my lord, 1 year later. So what he could have done, he has stated in his affidavit. What actually had happened is there was a cabinet decision to regularize the petitioners. There was an executive instruction to regularize the petitioners. There was a writ petition filed by the petitioners saying that they want a provincialization under the 2017 Act. That was the writ petition. Orders of this Honorable Court, which Lordship will find that executive instruction by the Commissioner and Secretary was actually set aside by this Honorable Court, and Lordship will find that at page 40, I'm sorry, my lord, at page 12, man. Page 39,
para 12.
para 11, madam. In the hierarchy of the authorities of the Constitution, the State Cabinet finds this place much higher than the Commissioner and Secretary of Government of Assam in the Secondary Education Department. In addition, the State Cabinet is binding on the Commissioner and Secretary, and on scheme of the Constitution, the Commissioner and Secretary has no jurisdiction of its own to deviate from a cabinet decision, take a different view. It is also noted that the claim of petitioner for regularization in services being dropped for teachers when the other similarly situated teachers were provincialized under the Act of 1996, whereas the Act of 2017 is for provincializing the services of teaching and non-teaching staff of the venture education. As the respective junior colleges are provincialized under the Act of 1996, it cannot be understood that they still retain the status of venture education institutes so as to be subjected to the provisions of the Act of 2017. This, my lord, was not the correct reflection of the prayers made in the writ petition. In this regard, having come to notice, my lord, we have also filed a writ appeal with a prayer for condonation of delay, which is pending before the division bench. My lord, settled position of law is that once an act is repealed, there can be no further provincialization under that act. Therefore, the petitioners had prayed that they be provincialized under the 2017 Act. Lordship may call for the records of the writ petition. That was their exact prayer. That was not granted by this Honorable Court, saying that it has to be done under 1996 Act. 1996 Act repealed, we cannot do it for 2017 Act. We are came in 2016.
Whatever it is.
While others who were regularized under 2017. We are ready to consider them under 2017 for the directions of this Honorable Court, if that is the direction. But if the direction is that we cannot do it under the 17, but have to do it under a repealed act, it is beyond us. The division bench
Where's the cabinet
if they want it under the 2017 Act, we are ready to act.
But
Let the records be called for, let it be.
this Honorable Court relied upon the cabinet decision. Ultimately, my lord, this is all hiding behind technicality. Ultimately, what was decided by the cabinet, that was sought to be overturned, And that has been interfered by this honorable court. So how you do it to rise above these technicalities, that is what is expected after a judgment is passed by this honorable court. That is what is expected of them. To keep us hanging, my lord.
Therefore, we have filed the writ appeal, my lord.
That writ appeal, apparently my instruction is that writ appeal delay.
Yes.
Application for condonation of delay is not even listed for the last 3-4 months because there are defects in the.
No, it has been listed.
When was
Please
it
notice,
filed?
but it has been listed, my
When
lord.
was it filed?
My lord, it was filed as, just have that information.
It was filed long back.
Lordship will have it. Lordship will give it 2 minutes. I have asked my junior to bring it, my lord. Check. 1 minute.
Where's
I
the
has-
cabinet decision?
Cabinet decision is not here on record. It is not here on
It's
record.
not part of the record. We thought that since it is a contempt matter, we have just annexed the judgment. We can place it if necessary. That is not a problem.
Place the cabinet decision.
My lord will allow, in that case, can this matter be taken up on next Wednesday, my lord? Let it be taken up on Wednesday. We'll produce the cabinet decision.
Perhaps Lordship will also call for the records of the writ petition to see what was the prayer in the writ petition.
Mr. I. Chaudhary, the council, the city council for the petition. Shall produce a copy of the cabinet decision dated 28/2/2016. As well as the office memorandum dated 2/3/2016 by the next date fixed. Stop. This is matter again on 15th. Along with WBC number
My lord, the earlier WBC number is
3816 of 2021, which was disposed on
17/11/2021.
17/11/2021.
I'm obliged.
See, Majumdar,
My lord.
there's a cabinet decision, office memorandum has been issued. I think the court is sticking to para 12
Yes.
of what has been. You'll have to do it. You'll have to do it. Despite the appeal being filed, condonation is yet to be considered.
Principal Secretary, Department of Social Justice and Empowerment was made party. So most probably I have not served copy upon them and they are not appearing today. So I may be allowed.
No, social justice.
Because subsequently, the social justice ISC bill 2123/2023 that was disposed.
Yes, that was.
Yes, Your Lordship. On the ground that WPT and BC department is no more in existence, something like that, Your Lordship was. As per submission made by Learned Counsel Ardhar, Your Lordship.
Yes.
On his request.
I'm appearing on behalf of Ardhar. Actually, we looked at the records and then we found out that a copy was not served to us.
Copy
It was
was-
served to Social Justice and Empowerment Department.
No, last occasion Ardhar appeared.
Yes.
But my lord, we have not received a copy yet. He's on.
I may be allowed to serve copies fresh, Your
Okay,
Lordship.
MS,
I will serve copies, Your Lordship.
S. Das Gupta.
Yes, Lord.
The counsel for the petition. Is permitted to serve a copy of the writ petition to the learned standing counsel.
Lordship.
Standing counsel.
Yes. Social Justice and Empowerment.
Justice and Empowerment Department. Within the course of the day.
Almost.
Within the court. When do you want?
Lordship, next week.
Yeah, based on 16.
My lord, we also pray for a copy.
Yeah, I will serve.
Forty order.
40. Huh? 40.
We have already issued an compliance order, Lordship, dated 26 September 2023.
What is the judgment?
Order page number 9, my lord. Direction is given page number 11. There are 5 and 6, my lord.
Like one second. Okay. তোমার WhatsApp number, তোমার email number আছে email number? WhatsApp email নাই। What? Your WhatsApp দিছিল। হ্যাঁ WhatsApp এ দেব না। এটা দিয়ে। তোমার dice code নাই কারণে একটু রিজেক্ট করছে। You have to challenge this order. Now you have to challenge this order.
Yes.
Maybe closed, my lord.
You have to challenge this order. Look.
Heard, Mr.
M. Hussain, my lord.
M. Wilson and the counsel for the petition. Mr. Assembly Chisti. The council
As in control.
appearing on behalf of the sole responsible has produced an order dated 26 September 2023 issued by the Director Elementary Education Assam, by which the claim of the petitioner for provincialization of his or her for provincialization of his service has
It's hard. No, sorry, no,
has been rejected. So, in the view of the matter, this court is of the consider of that substantial compliance has been made with the order passed by this court. Accordingly, contempt petition is closed. The order dated 26 September 2023 is placed on the court. We challenge.
41.
41 lawsuit, I need some accommodation. B posting is out of session due to his personal difficulties lawsuit. I have already informed the counsel for a petition of Ann Bora lawsuit. So any day next week lawsuit.
Your Lordship, by order dated 10/5/23 in IA 1006 of 2023, respondent number 4 was implemented, but notice was not issued. I may be allowed to take.
That can be issued lawsuit. Either Commissioner Finance.
Finance.
Where's CIA?
I is not listed, not shown in the cause date lawsuit. Huh? That's it. That's my number 2. Okay.
Respondent 4 has been impleted.
Yes, Your Lordship, as per the officer note.
Have you filed an amended cost title? 4 has been amended. Heard, Mr.
And Ahmed on behalf of Mr. N. Bora.
And Ahmed, let me counsel appearing on behalf of Mr. N. Bora, let me counsel for the petitioner. Issue notice on the respond number 4. Petitioner to take steps for service of notice on the respond number 4 by respect of the which Dr. 4 will.
Forty-three.
May I please, Your Lordship? Lordship, we are not pressing the matter, Lordship.
You're not pressing the matter.
Yes, Lordship.
They've complied with the orders.
Yes, Lordship.
Can I record that?
Lordship.
Can I record that?
तो senior कल की question है जो
I took,
question
order complied as well.
Okay, MS.
S.R. Majabhuya.
S.
R. Majabhuya.
R. Mazar Bhuya, learned counsel for the petition. submits that the respondents have complied with the order passed by this court. So, Mr. Who appears?
No, none, none.
Accordingly, this contempt petition is closed.
44.
Please, your lordship, my lord. As per last order, my lord, the respondent was supposed to file compliance report, my lord.
Yes,
Is the complaint report with me? I am sorry, look, I cannot download it, Lordship. Lordship, can you take it after some time? I'll just put it.
Lord, any other day, my lord, I have some problem today, my lord.
has it been complied?
It is, order has been issued, Lordship, and in view of the above, the petitioners were placed before the screening committee, and they did not fulfill the criteria laid in the cabinet memorandum, and therefore they could not be accommodated in any of the post of teacher or tutor under the illegal or irregular category. That is the compliance order, Lordship, issued by the secretary.
This is of that order, my lord, maybe, maybe disposed of, my lord, this contemporary.
I'm just submitting to the through mail, Lordship.
Heard Mr. AHMR Chowdhury on the council for the. Mr. SM Chistil and the council appearing for the
Lordship, sole respondent, Lordship.
sole respondent.
Yes.
Has produced an order dated
11/4/2023,
11/4/2023,
issued by the secretary, Lordship,
issued by the secretary,
Government of Assam, Education, Department of School Education.
Government of Assam, Department of
School
Education, by which the case of the petitioner
Has been rejected.
has been rejected. So. After considering the order dated
11/4/2023.
11/4/2023, this court is of the consider opinion that the substantial compliance has been made with the order passed by this court. And accordingly, this contempt petition is closed.
My lord, liberty may be granted to the
That you
petitioner.
have, that you have.
That is always there, Lordship.
Can you finish a copy now?
I am just giving to the
Copy-
mail. I'll get a printed
Copy
copy.
of the order dated
11/4/2023.
11/4/2023
2023.
is placed on the court.
Obliged.
46.
Yes.
May I please read?
I filed an IA for impleading the Commissioner Secretary Higher Education. Now just my friend informed me that he's no more in the office, so new incumbent is coming in there. So Lordship may allow to withdraw this IA and face a file to implement the new incumbent.
Mr. A. Chetri, on the counsel for the applicant, prays for withdrawal of this present IA with liberty to file afresh. Mr. A.R. Tabildar, on the counsel appears for the.
Higher Education Department.
No. This
For that.
this is a contempt matter.
Now, Lordship, then notice it.
IA is accordingly dismissed on your liberty as.
Obliged.
47.
May I please, lordship? This is contempt application, my lord. Instruction was sought for. Order has been complied with, my lord.
Which is the order page?
Page number 18. Relevant portion.
505.
Para 5 minutes. Page 3, my lord.
Page
3, my lord. Order dated 7 August 2023.
Yes, have you got a copy?
No, my lord.
Furnish your copy. We'll close the contempt. But Mr.
C. Chakraborty.
C. Chakraborty, led the counsel for the. Mr. S.R. S.R. Rabalan's counsel for the respondent number
Sole respondent. Sole respondent.
for the sole respondent. As furnished in order dated 7th August 2023. issued by the Director of Education. Petition. Wherein the petitioner's claim. Where the case of the petitioner. No, where the petitioner's claim. For error salary, isn't it?
Yes.
And regularization of service was rejected. Upon consideration of the order dated 7th August 2020, this court is of the consider the substantial compliance has been made. And accordingly, this contempt petition is supposed. You can challenge this order.
Okay.
The order dated 7th August 2023 is placed on the court.
May I please? Can I peruse the last order, madam? That is 26/4/2024.
Have you filed your affidavit?
No, madam.
Have you taken dusty service?
Yes, madam, I have taken dusty service. I have not filed it yet.
You are supposed to file it.
Yes, madam. Only my fare is today, my lord. Since August 2023, they are not releasing my salary. As well as they are not allowing me to resume in my duty, my lord. And in the order dated 11/10/2023, the direction was there to pass any appropriate order. Direction was given to the Deputy Inspector of School, madam. They are not taking any initiative to their extent, madam.
Yes.
Madam, in this case, I have received instruction, madam. Petitioner has applied for earned leave on 31/5/2023, madam. 31/5/2023. And she was allowed up to, my lord, 1/6/2023, my lord. Thereafter, she did not join in the school, my lord. Thereafter, my lord, she did not join and she did not continue her service, my lord.
When did she join?
My lord, till this, my lord, she has not joining in her post, my lord.
This is not
For
right.
that reason, my lord, we have issued show cause notice on 22/11/2023, my lord. And report of the
Show cause on?
22/11/2023, my lord. Till date, my lord, she has not submitted any reply to that also, my lord.
Then I have not received that, so I am not aware about the so cause notice, madam. I have not
When
received.
did you file this writ petition?
2023, madam. September 2023, madam.
So it was after the filing of this writ petition, the show cause notice was issued.
My lord.
Yes, my lord, I have not received that regarding that.
Are you sure?
Yes, my lord, as per my instruction, my lord. I asked my client.
Just now I submitted, my lord, show cause notice has been issued. He has to take some instruction from the client also, my lord.
Then I will take instruction.
Give me your.
My lord. And if you can violate my language. Show cause notice.
No, anyway, sure.
My-
You have the instructions
My-
in the English?
My lord.
Posted 11/2023.
Okay, heard, mister.
Madam, one thing, madam. Page number 53. That is the representation I have submitted before the DO board research on 5/6/2023.
Page number?
53.
Oh.
It is not my representation. I have submitted before the DO, my lord, to allow me to resume my, in my duty, my lord, after the leave period, after the 4 months, my lord. But they are not passing any appropriate order. They are not considering my application. Thereafter, again, I have submitted one more application, that is page number 55. On 4/7/2023.
Okay, that
And
we
there
have
are-
considered.
There may be considered, my lord.
No. Since the show cause notice is already.
Thereafter, they have issued a show cause, my lord.
We'll see what happens.
My lord.
But Mr.
A Boro, my lord.
A. Boro,
A Boro, yes, sir.
General Counsel for the petition. MS Tutel and the Standing Council,
Elementary.
Elementary Education Department. Submits on instructions that the petitioner was granted early till 31/5/2023. And she was supposed to join on 1/6/2023. Stop. However, petitioner is yet to join the school till date. Stop. It is also submitted that the show cause notice was issued to the petitioner on 22/11/2023. Stop. The learned council for the secondary education, for the elementary education department. Then the standing council for the elementary education department is directed to file an affidavit within
2 weeks, my lord.
2 weeks. Stop. Award service report on the respondent number 5.
Respondent 8. towards service.
Respondent 8, my lord.
Our service report on the respondent number 8. Stop. Then the counsel for the petitioner also submits that that the petitioner has taken steps for service of notice on the respondent number 8 by justice service.
Yes, my lord.
And press for.
I have taken steps,
How much
I will,
time you require to file your affidavit?
1 week, my lord.
Press for a week's time to file affidavit. Press.
Yes.
List after 3 weeks. You can take back this.
My lord. Oh, bless.
Right.
49.
It is your lordship. It's actually a stay.
Before my senior starts, my lord, this honorable court stayed the execution of an OM, my lord, stayed office memorandum issued by the government of Assam. Now, if the stay is vacated, then entire writ petition will become infructuous. So better if the entire writ petition is heard and finally disposed of, I think that will solve the entire purpose, my lord.
But I have
Because this is with regard to a scheme initially floated by the government of Assam in the year 2012. And thereafter another scheme was floated in the year 2023, which was in derogation to the earlier OM as well as, my lord, rules of the education department. So on that count, we have challenged that the scheme is in violation of the rules of government of Assam. So if the entire matter is heard, perhaps, my lord, that will be proper. I leave it to my senior friend, my lord.
My lord, I have no objection to the matter being heard. The only anxiety, my lord, is my continuation because I am a national awardee teacher. The scheme which my learned friend is referring to, my lord, is for continuation for a period of 2 years or till a regular incumbent joined to continue as in the post of in-charge principal till the regular principal joins. My lord, I am a national awardee teacher. In that year, I was the only national awardee from the state of Assam. So, my lord, the stay of the OM, insofar as others are concerned, my lord, I would have no objection. But since I am continuing, my services may be protected. To that extent, if the interim order is modified, my lord, only to that extent.
So far as, I'm sorry, I'm sorry. So far as my senior's client is concerned, my lord, she is continuing as a principal in charge, as on date also, my lord.
My lord, that is true, my lord.
That's true. So there is, it's not that I have taken a plea also in my reply that she is not affected by the stay. stays for the entire merit of the scheme, the stay order was passed by this court. But so far as my senior's client is concerned, she is continuing as principal in charge. Milord, the scheme is originally like, Milord,
Who is the OM?
OM, my lord, will find the original OM, page 23.
Of the IA?
No, Milord, writ petition.
Huh?
Writ petition. The first OM,
1 minute.
Rules. He took from. Issue observation to the.
Yes,
page 23, my lord.
20.
23.
The 2012 one.
This is the original one, my lord, from where the first scheme, my lord. 16 June 2012. May I read, my lord? Scheme for re-employment of teachers conferred with National State Award for their outstanding contribution in the realm of education. The teachers rendering outstanding meritorious service are given public recognition by conferring national award by the union government and state award by the state government with a view to get optimum utilization of their excellent services. The Governor of Assam is pleased to introduce the following scheme for re-employment of the teachers having been conferred with the National State Award for their outstanding contribution in the realm of education, subject to physical fitness, mental alertness, willingness to work beyond the date of superannuation. Number one, the teacher conferred with national award shall be re-employed for a maximum period of 2 years beyond the date of superannuation of or till attaining the age of 62 years, whichever is earlier. Number two, teacher conferred with state award shall be re-employed for a maximum period of 1 year beyond the date of superannuation or till the age of 62 years, whichever is earlier. All categories of re-employed teachers shall be designated as awardee teacher and re-employment shall be made against separate post in the same school to be created for the period of re-employment, which shall be personal to the incumbent. This is important. The state awardee shall not exceed 27 in numbers in a year, covering all districts in the state, including district under BTAD and 6 schedule areas. Further, with the re-employment, there will be an extra hand in the school. Hence, the base post will be kept in abeyance. At the end of the year, the appointing authority shall invite willingness from the intending awardee teachers to work under the scheme as per form as at Annexure A through the inspector of school concern. On receipt of willingness to work under the scheme, the appointing authority shall prepare a list after verification as may be required with regard to the receipt of award, date of superannuation, etc., and shall submit to the government through the concerned directorate. The director shall compile the list and furnish the government for approval. The government in the concerned department shall accord approval after causing such verification as may be required and shall forward the appointees list to the respective appointing authority for appointment. Appointing authority then move for creation of supernumerary posts through concerned administrative department. The re-employment is for the purpose of utilization of his meritorious service as a teacher, and his re-employment would therefore be as an assistant teacher, graduate teacher, or subject teacher, or any other category of teaching assignment, and would not therefore affect the post of headmaster principal of the institution. So scheme says there will be awardee teacher will be taken for another 2 years against a supernumerary post created, and they will be known as assistant teacher, graduate teacher, subject teacher, or any other category of teacher. That will be a supernumerary post. Now, this entire, the very heart of the scheme was sought to be amended by the impugned scheme, that is page 26. It says in the first paragraph of page 26, it's the reiteration of this 2012 OM. But second paragraph is the penultimate paragraph, my lord. May I read, my lord? Scheme for re-employment of teachers conferred with national and state award for their outstanding contribution in the realm of education. Government in secondary education department introduced a scheme for re-employment of teachers conferred with national state award for their outstanding contribution in the realm of education via office memorandum dated so and so. As per provision of the said scheme, a teacher having been conferred with national award may be re-employed as an awardee teacher for a period of 2 years beyond the date of superannuation or till attaining the age of 62 years, whichever is earlier. Likewise, a teacher having been conferred with state award may be re-employed as an awardee teacher for a period of 1 year beyond the date of superannuation or till attaining the age of 62 years, whichever is earlier. In both the cases, awardee teacher after being re-employed is required to relinquish his or her substantive post and to rejoin as awardee teacher, which is ex-cadre supernumerary post to be created separately. Now, till here, fine, my lord. Now, the second paragraph. However, it has been decided that in case of teacher conferred with national award and holding substantive post of principal or headmaster at the time of superannuation, she shall thereafter hold the substantive post of the teacher in the extended period and may be allowed to hold the charge of principal or headmaster in charge, as the case may be, after being employed and after rejoining as awardee teacher with due process as stipulated in the OM, till the post is filled up by a regular incumbent or for a period of re-employment, whichever is earlier. Now, the earlier scheme has been completely changed by this particular paragraph, because supernumerary post has to be created. Awardee teacher will be placed in that supernumerary post, giving the nomenclature of assistant teacher, head teacher, so and so. Now, here they have diluted that entire thing of supernumerary, creation of supernumerary post. Here they have said that the substantive post which he was or she was holding at the time of retirement, she will continue to hold that post for another 2 years. So, if that be so, then, my lord, how can a retired person hold a substantive cadre post? That is our objection. Second thing is that if a teacher, a regular selection is to be made to the post of principal, my lord, while making the selection, my lord, there is an OM issued by the government of Assam which provides that 1 mark is given for experience as in charge principal. 1 mark is given by the selection committee. Now, if anybody or if any person is allowed to continue in that substantive post or cadre post of principal, then that person who would have been a principal in charge and would have been eligible to get 1 mark, he'll be deprived, my lord. Because in the event of creation of supernumerary post, awardee teacher is in supernumerary post, main post fell vacant, another person become principal in charge, become eligible to get 1 mark in the regular selection of principal. So that person is prejudiced or he is deprived. So under this fact situation, and another important is that the 2012 OM was issued in the name of governor. The very first paragraph says, here there is nothing. It has been issued by the Secretary of the Government of Assam. It is not in the name of governor. Milord, all these grounds we have taken. So far as my learned friend client is concerned, she was appointed as awardee teacher, and she is at present she is holding the post of principal in charge, Milord. She is continuing also. So my contention in the writ petition is that in the IA is that she is at present she is not prejudiced by the stay. Because this honorable court stayed this impugn OM. This honorable court has not passed any order that what will be the consequential effect or to stay the appointment of my learned friend's client. Prima facie, this court has found that yes, this is in violation of the earlier OM as well as the other government rules. So that's why this was stayed. So if pursuant to stay order, government passes any order with regard to my friend's client, then would have been different. But she is continuing as in charge principal.
But you never know.
No, as on that there is nothing.
So that is why, my lord, if there is a observation from lordship, a clarification that this the stay order may not affect the petitioner, the applicant in this case, my lord, that would suffice if lordship may hear the matter. But insofar as my learned friend's submission is concerned, that about the 1 mark being given for holding charge of the post of principal in charge. My lord, that has been done away with. That is no longer there in terms of the new rules. So, my lord, at the moment, if my lord wishes to hear the matter in its entirety, that may be done only with that observation that the stay order will not affect the applicant in this case. That may suffice. my lord.
Perhaps in my humble submission, going by what pleadings my friend has adduced, she is continuing as in charge principal. my
That
lord.
is why, my lord, I am continuing
And
even
there
as
is
on
no
date.
embargo
So
on that.
therefore, my lord, the heavens will not fall if, my lord, that clarification is made.
Okay.
my lord.
So in my humble submission, my lord, it's better.
So far as
perhaps-
the OM is concerned, my lord, the stay may continue, but it may not affect because my appointment
It's-
was prior to the stay order. My lord.
It's premature, my lord. The IA
Not
is
premature.
premature because
Not,
that
my lord, if
situation has not
after I am removed, how can I come for this vacation of the stay? It
my
is
lord,
not
there-
premature at all.
there-
My appointment, my lord, was 30th of November 2022. The interim order, my lord, is in February.
So
my
other
lord.
also interim
March,
order is
my lord.
not applicable
22nd
in
of-
our case.
My lord, if it is not applicable, my lord, then
That is my submission, my lord.
that is
But
why,
the
my lord,
fact
that is why
that-
the clarification
fact
is
is
required
that-
from
that
us.
The cause of action is not there before the petitioner. No order has
the-
been passed
in the
dislocating her.
You say, you say. Heard Mr. P.T. Nair, then the counsel for the applicant. Public respondent number
Sorry.
Uh,
Four, my lord. Four.
in the writ petition.
Four in the writ petition.
Yes, ma'am.
Public respondent number 4. In WBC number 1603 of 2023. Stop. After considering the matter at length. Oh. Also heard Mr. H.P. Das on top. Then counsel applying for the opposite party number 1 oblique writ petition. Stop. After considering the matter at length. This party shall be considered that instead of considering the present IA, it will be in the interest of justice to dispose of the main writ petition on merits. Accordingly, yes. Have you filed your affidavit?
Yes, my lord. Oh, no, in the writ petition?
Petition.
Writ petition, no, my lord. The state also
State
has to
also
file.
is required to file the affidavit, my lord.
State's
because
affidavit will be
it's
essential.
there
my
one.
lord.
Accordingly, list these matters again on when?
No, the state kit, yes.
State.
List the matter after 3 weeks. So, para. It is also provided that the interim order dated 22/3/2024 passed in WBC 1603 of 2024 shall not have any effect on the service of the applicant. Public response number 4 in WBC 1603 of 2022.
My lord. Deeply obliged.
Then can we close the IA?
Yes, my lord. I should be disposed of. Because the writ petition will be heard by.
Okay, then on top, what is the list after 3 weeks, no?
That is in the writ petition.
IA is accordingly disposed of. And in the main writ petition. Part Mr.
HK Das.
HK Das, Learned Counsel for the petition. Also heard Mr. P.T. Nair, Learned Counsel for the respond number 4. Chishti, one time. Mr. S.M.P. Chishti, Learned Standing Counsel, School Education Department. Appearing for the respondents. 1, 3,
One,
1 and 3,
One.
1 and 3.
as well as Mr. P.T. Nair. Learned Counsel for the respond number 4. Waits for 3 weeks time.
My lord.
To file the respective affidavit. So, there is a lot, list up to 2 weeks.
My lord.
The
Deeply
interim order may continue, my lord. Interim order
Interim
passed in
order
the writ petition.
Passed in, interim order passed in to continue the next week.
My lord, as modified by today's order in the IA.
That
No,
is
that
already
is in the
there,
writ
yeah.
petition only.
My lord. Deeply obliged.
Clear.
51.
I need some instruction lordship because it is
My lord, today it is fixed for interim.
that may be
order.
there, but notice it is only second time this is issued. in
And
the last date,
no,
lordship.
let me, my lord, finish my submission first. My lord, today, as per the first order, my lord, we have taken steps upon the respondent number 4 and completed the Dusty service. And Dusty, we have filed the affidavit also.
Where is your affidavit?
Affidavit, it was filed yesterday, my lord, received by the filing section yesterday.
Yesterday was what date?
Yeah, 9th, it was 9th of May 2024, it was received. And registered post also submitted immediately after issuance of the notice. It is also dispersed as per the office note, my lord. And regarding the interim order, my lord, there's an observation in the order that the interim order will be considered on the next date, that is today. Here mainly, my lord, agree.
Not considered issue a notice
That is
on the pair
that
for
is
interim
honorable-
also returnable, that is
Yes.
there. But it says the far-reaching consequences lordship. So lordship may.
No, let me submit, my lord. What is the consequence there? What is?
I need the full instruction from the department lordship.
My lord, let me just complete my submission. Interim order, the person who is given the charge of the, my lord, school, my lord, he admittedly junior to me. And I am the senior most qualified teacher of the school, my lord. That is the simple thing, my lord. That is nothing so much difficult to, my lord.
Where's the order?
My lord, impin order page 66. The type copy 66. my lord.
How do you say that you are senior to him?
Because he has been transferred to my school, my lord, on 25th November 1999. I've got the letter to me. I'm serving as graduate teacher in this school, my lord, on since 30/10/1998, and she has come to my school, my lord, on 3rd of December 1999 on her own request. And in the order itself, it's written that no senior past service senior to be counted.
So transfer is made on a request.
Yes,
So her seniority will start counting from
on the date of joining.
when did she join?
She joined, my lord, from 3rd of December 1999.
Then
I joined on, my lord, 30th October 1998.
where's that?
Page number 7, my lord, you should find. I've given the chart.
Page number?
7. Comparative chart I have given.
Yes.
Therefore, I am senior, my lord.
Yes,
Well, as he has already taken the justice service upon the response 4, let the response 4 appear, Lordship, and Lordship, because he has not given any, this honorable court has not issued any interim order.
no interim order was not, but notice on interim was.
Notice on interim was on the pretext that perhaps he would take the justice service and the response 4 would appear. So I think as he has already taken, it will take some
She
time. to appear.
herself has received the copy, madam.
Yes, definitely she will appear, Lordship, and only after appearance, Lordship may.
That will be final disposal, therefore it will be final
Yes,
disposal.
let it be, Lordship, let it be.
Interim or is always, my lord, the first day or in second day.
This observation was only given by this honorable court only on the pretext that he would take justice service, and in the meantime, perhaps that response 4 would appear. As he has already taken, and she would appear.
Prima facie, I have got the case, my lord.
Yes.
And I have complied with the conditions given in the first order, my lord.
The impugn order is of February, and he has approached this court after 2 months.
That is why, that is the
April.
reason, that's why, my
So-
lord, the honorable court directed me that you comply with the service. I have done it.
Let her appear, Lordship. Lordship will consider it finally.
She may appear, she may not appear, it's up to her.
Then your Lordship will proceed with it.
But Mr. P. Professor and counsel. for the petition. Stop. It is the case of the petitioner that he joined the Uralguri Higher Secondary School, Golaghat, as graduate teacher on 30/10/1998 and has been drawing the graduate scale of pay from the date of joining the said school. Stop. The respondent number 4.
Four, my lord.
4 also joined the Uralaguri Higher Secondary School, Golaghat, on 3/12/1999 on being transferred from Melamura High School, Golaghat district on her own request. Stop. The order. No, on her own request, by order dated 25th November 1990. Stop. The order dated 25th November 1990 further stipulates that the respondent number 4 cannot claim seniority against the existing staff of Kuralguri Higher Secondary School. The petitioner therefore submits that as he is senior to the respondent, he should have been allowed to hold the post of in charge principal of the said school. Stop. However, by order dated 12/2/2024, the respondent number 4 has been permitted to act as in charge principal of the Uralguri Higher Secondary School, District Golaghat. Stop. Para. Mr. SMT Chishti. Then standing counsel,
It's secondary education.
secondary education, what do you want?
My lord, it may come on 20th of May, my lord.
Yes, sir. Yes. 20th of May. I have the date.
Press for some accommodation to enable him to receive instructions. Para. Mr. P. Purgaster and counsel for the petition also submits that the petitioner has taken steps for service of notice on the respondent number 4 by Dutchess service,
Which has been received by herself.
which was received by the respondent number 4 herself. And an affidavit to that effect was filed on 9/5/2020. Registry to verify and place the said affidavit on report. He found in order. So, place the matter on 25/2024, on which date the prayer for entry shall be considered.
Yes.
Okay. Matter may come for admission, madam.
It will come, no, let the notice, let us see the.
Registry will directed, my lord, to give the service report, my lord, with regard to post, registered post. They will give the tracking report. That will be observed, my lord.
Registry is also directed to file an updated
Status report with regard to registered post.
status report with regard to the service of notice on the respond number 4 by registered post.
Obliged.
18, admission.
Meet legal lordships. Case relates to provincialization of the service of the petitioner, my lord. Petitioner was appointed appointment as a LDA, my lord, on 26/1994. At that time, school was not provincialized. My lord. Then his school was provincialized 1996, my lord. Then in this case, my lord, this some of the drop, they were at the time of the provincialization of the school, they were dropped, my lord. LDA, the petitioner was dropped. He was not regularized, my lord. Then they have approached before this honorable court.
Just a minute.
Yes, ma'am.
Additional affidavit was filed on.
Yes.
8/5/23.
Yes, my lord.
Who appears?
Madam, it's a use for my ability here, she is on like the court number 26. Right now, the last item is going on. May I can may pocket lot, I will call you.
This morning he wanted some time to go through the additional affidavit.
No, this is the two-page additional affidavit, my lord. I have shown that they have filed affidavit showing that I was not, my service was not regularized because I was a drop, second drop, my lord. I showed that all the drop who were provincialized, they all were second drop. That is, I have mentioned only.
What second drop?
Second drop means there is a, at the time of the provincialization of the school, my lord, one post is already been regularized at the time of provincialization. And in addition to that, another LDA was appointed because due to increasing the students, my lord, like that. Then their service were approved by the government in the meantime, before the provincialization, my lord. After provincialization, they were only one post is provincialized because there is a chart that one post LDA is provincialized, one LDA grade 4 is provincialized. Then he was left. He was second drop. Second drop in the means the first one, since he was regularized, my lord, he was left out, my lord. Then in spite of that, whether his school was provincialized, they were working and they still he is working, my lord, in that school, my lord, as a second drop teacher at the LDA, my lord. And in this case, my lord, this honorable court has passed an order. Lordship, kindly peruse the appointment letter, my lord. Initial appointment letter. Page, my lord, type copy 18. It was appointed by the headmaster and he is a secretary of the managing committee. At that time, school was not provincialized, my lord. School was provincialized 96. Then lordship turn up, his joining was 2694. It is page 20. Then his service was approved, that is page 22. And that approval was made by the inspector of school, Gwalpara. His name is Abdas Samad Sheikh.
Your name is?
Abdus Samad Sheikh, my lord. Then lordship turn page 23.
See the approval letter, order.
Approval order.
19/11/94.
94, yes. Then lordship's
Read
decision.
it, just read it.
As per resolution adopted by the managing committee, Podumpara Anchalik Madrasa High School, the appointment of following incumbents of the
school are hereby provisionally approved from the date of joining shown against each that the serial number 2, 3, and 4, the government will not take any responsibility at the time of provincialization of their services.
Yes.
Yes, it is written. Then, my lord, what happened? Then all the, but in Act, my lord, it was written that the person who is left out, they will take by the government. It was written like that. My lord, though it is written, my lord, at the time, in the year 2023, this honorable court passed an order. Lordship, kindly peruse the order.
Which order?
That is 36, page 36.
Yes.
May I read, my lord?
Hmm.
The petitioner in this group of cases, except in WPC number 66, and are teachers of different LP school, ME, MB, higher secondary school of the state, who were appointed by the managing committee prior to the taking over the schools under the provision of Assam Elementary Education Act 1974 and the Assam Secondary Education Act 1977. On such taking over being affected, the services of the petitioner were not provincialized. They therefore claim to be drop teachers. The petitioners in these three other writ petitions mentioned above are similarly situated members of the non-teaching staff of the schools in question. The relief of the regularization of services is the essence of the relief claimed in the present bunch of cases that have been grouped together. In view of the common thread that is discernible in each of the cases which give rise to a distinctly identifiable common question of law, it will hardly be necessary to traverse the factual metrics in each of the cases, except to put on record that all the petitioners claim along years of the services rendered either on national pay or even on honorary basis. Each of the petitioners claim continuously of service since their initial appointment, and further asserts that such continuation, which continues till date, have been with the knowledge and concurrence of the district level officers of the education department. There is need for the post held by the petitioner. It is claim sought to be fortified by the documents brought on record, which is most cases would go to show that the recommendation made by the managing committee have been duly supported by the requests made by different distinct level officers for sanction of the post and for appointment of the petitioners on regular basis against the said post a legal rights of their consideration of their cases for regularization is therefore claimed in each of the writ petitions. The respondent state has filed an affidavit, WPC number 539903, with a prayer to treat the same reflection a common stand in all the cases. The state has not unmindful of the plight of the drop teachers claim of the state. Over 6,000 such teachers have been adjusted against regular posts in accordance with the norms, policy guidelines introduced from the time to time. Such norms and policy have been periodically reviewed in the light of the experience gained and in the ever changing commitment and the constraints of the state. The state in the affidavit file has enclosed a policy documents dated 13/1/2003, which is now introduced to cover the cases of the drop teachers. Such cases will be dealt with by the state in accordance with the said policy, and all those who are found to be eligible will be regularized in a phased manner as indicated in the policy. The policy, it is conceded, would apply to members of the non-teaching staff whose cases will be similarly dealt with. The policy documents dated 13/1/2003 is not under challenge in any of the cases. Learned counsel for the petitioner have also do not raise any question with regards to the validity of the norms prescribed by the aforesaid policy document in course of oral argument advanced. However, D. Mazumdar, learned counsel for the petitioner, in course of his arguments, he contended that perhaps some suitable adjustment in condition 1 and 2 of the policy documents would make the policy introduced more broad-based and fair, a position agreed by the S.N. Sharma, learned senior standing counsel, appearing for the respondents. Condition number 1, the respondents agree may be read as covering of the all cases drop teachers in service as on the date of the provincialization of the content school, whereas the requirement of the approval of the appointment made by the managing committee as embodied in condition 2, as agreed by the respondents, could be reflected by the document acknowledging rendering the service by the drop teachers. Furthermore, in the affidavit file, the state will be stating that the regulation, when made, would be prospective, has agreed to give the benefit of the previous service rendered for the purpose of the pension and retirement dues. As a policy has been framed, to deal with the case of the drop teachers, it is examining that all the cases be dealt with in terms of the policy adopted. In view of these branch cases will stand now disposed of in the following direction. The cases of the petitioner in each of the case will be considered in accordance with the norms, criteria and eligibility condition prescribed the policy documents 13/1/2003, subject to the modification in condition 1 and 2 as stated above. The Chief Secretary to the Government of Assam shall, within 7 days from the day, constitute a committee to examine the cases of the petitioner in the present branch of cases, and such cases as may be referred to the said committee from time to time by the court. As the said committee will be executing and implementing the policy decision taken by the state, this court considered it appropriate to leave it to the discretion of the Chief Secretary to the Government of Assam to decide on the composition of the committee, with the suggestion that the committee may be high-powered committee consisting 3 members of the present Secretary to the Government of Assam Education Department may act as a member secretary. The committee, upon due verification of the cases before it, shall within 6 months from the date of this constitution prepare district-wise select list drop teachers eligible for the regularization in terms of the norms and criteria laid down as per decision of the one above. The eligible petition on being identified shall be arranged in the district-wise list in order of seniority. Suitable adjustment in the place assigned in the district-wise list as may be required upon consideration of such other cases which may be referred to the committee in the future shall be made by the committee. Appointment against available post in each district shall be made on the basis of the list prepared. All appointments will be made prospective but will carry the benefit of past service for the purpose of competition of the pensionary benefits, my lord. Then, my lord, after obtaining the order, my lord, nothing has been done. Then an advertisement was held in the year 2005, my lord. Against that advertisement, they approached this honorable court, and honorable court passed a further order, my lord, that is phase Tapan Chandra Das and others. Page 47, my lord.
Yes.
The petitioners in all cases under consideration came to be drop teachers, LP, ME, and high schools of the state of the Assam. Drop teachers have been understood to those who were appointed engaged prior to the provincialization of the school, but whose service were not provincialized, but were dropped. The court had earlier dealt with the rights of the such drop teacher in a group of above 39 writ petitions in Civil Rule number 1579/71/98 and other connected cases. All the aforesaid cases were disposed of by the court by judgment and order dated 1/9/2023, directing consideration of all cases by the court appointment committee in the light of the eligible norms spelled out by the government order dated 13/1/2003, which was to be some extent modified by the court by its aforesaid order dated 1/9/2023. Persons found eligible were to be regularized if sensitive vacancies in a phased manner. The consent writ petitions have been filed to contend that, notwithstanding the order dated 1/9/2003 passed by this court, Civil Rule 1571/98 and other connected cases, the entailment of the petitioners have not been finalized. Instead of advertisement 6/12/2005 has been issued in the newspaper inviting application for filling up the vacant post of the high school, LP school, ME schools. The short projection of the writ petition are to be affected that the entitlement of the writ petitioner to regularize in accordance with the earlier order of this court should be finalized, and such finalization, if appointments are to be made pursuant to the advertisement issued, a situation may develop where no further post will be available, thereby disentangling and the eligible person to appoint through they may be entitled to such appointment. Mr. M.K. Chaudhary, Learned Senior Counsel, appearing on behalf of the department, has submitted that pursuant to the order dated 1/9/2003, passed in Civil Rule 1571/1998, a high power committee was constituted to examine all the cases drop teachers in the state. Public notice were issued on the newspaper inviting eligible candidates to submit their particulars to the design authority for due verification and consideration. According to Sri Chaudhary, the high power committee in turn constitute a screening committee to scrutinize the cases to all eligible persons. On the basis of these documents available, Sri Chaudhary has further submitted that most of the members, if not all, were given personnel hearing also. Therefore, thereafter, the high power committee has prepared a report for submission of the state government for each acceptance. However, in view of the pendency to the present cases, the state government, according to Sri Chaudhary, had thought it proper, proper to defer accord is to prove or otherwise to the recommendation of the high power committee until appreciate leaves is granted by the court. Sri Chaudhary, Learned Departmental Counsel, has also placed before the court the report of the high power committee, which is two parts consideration of the said report as placed before the court would go so that in so far as high schools are concerned, 508 cases of drop teachers were considered by the committee. Out of the 348 teachers have been found eligible. So far as ME school are concerned, the report goes to the indicated that out of the 778 cases considered by 93 cases were recommended. However, according to the high power committee, 271 cases LP school teachers were considered. None could be recommended for regularization because so far as LP school are concerned, there can be no drop teachers. The reasons are for aforesaid few taken as a event from the report of the high power committee, and the same will be dealt with at a large stage. Sri Chaudhary has further submitted that it has been decided by the government that 5% of the vacancies advertised by the notice dated 3/12/2005 have been embarked by the government for being filled up for the category of drop teachers. The facts notice above have reduced the dimension of the case to extremely constrained limits so far as high and middle schools of the states are concerned. The high power committee on due examination has found 346 and 93 teachers eligible to claim themselves as drop teachers. Therefore, the entitlement to regularize the in accordance with the government policy decision 11/1/2003 and the order of the court 1/9/2003 passed in 1571/98. If that be so, the court finds no impediment granting leave. If at all any leave is required to enable the government concerned, the report of the high power committee and take its own occasion of the matter. The government, upon consideration of the said report, if it agrees with the same, will nullify the name of the petitioner found eligible to two leading newspaper, one of which a vernacular paper, as 5% of the advertisement vacancies are stated to be available, and the number of the vacancies will be more or less adequate to regularize the persons found eligible in the report, that the high power committee may be approved by the state. The court directs that such appointment may be made by the government if it is so desired. In doing so, the court goes by the clear stand taker by the state that presently there is no need for appointment of the teacher. The person who has not been found eligible as drop teacher by the high power committee, whose names will be self-evidence from the list drop to be published in the newspaper, are left with the option of seeking remedies if in law, if so advised. High power committee has taken the view that unlike ME and high school, who were required to be submit a list of teachers who were working along with the students' population, whose proved a rational and objective basis for determination of the actual need of the teacher staff of the school, which in turn facilitate identification of the drop teachers. There was no requirement in the case of LP school teachers. An argument has been offered by Sri Chaudhary, Learned Departmental Counsel, that LP school, in the absence of any such requirement, may be required a large number of teachers, out of whom only a few were really necessary, are also all such other teachers to be understood as drop teachers because their service were not provincialized in initial stage. Mr. Chaudhary has also drawn the attention of the court to the specific inform recorded by the High Power Committee that at the time of the provincialization, LP school posts were sanctioned on one post of the need, performs and seniority that the whatever number of posts were required in terms of the student population was sanctioned. The facts stated above, if they are correct, may sustain the view recorded by the High Power Committee with regards to LP school teacher. However, the said school have to be supported by requisite evidence after necessary inquiry in the light had been made in regards to the courts has looked into part 2 of the report of the High Power Committee, which are compliance of the basic facts collected by the screening committee in none of the completatory record upon inquiry by the screening committee. There is any evidence of the fact that any such exercise was performed by the said committee. It is considered view that the court that in case of the LP school was really required to be determined a teacher ratio and the time when provincialization were made, and to sanction that many posts of the teacher that stood justified on the basis of the student population. If there were need for more teachers, yet lesser posts were sanctioned, the teacher already working in order of the seniority to the extent of the post necessary will be dropped teachers as the aforesaid exercise does not appear to have been performed by the High Power Committee. I am of the view that the said committee should be required to perform the acts once again insofar as LP schools teachers are concerned. With the above observation direction, all these requisition stand disposal with further direction that necessary consequential action in terms of the present order will be initiated as and completed by all concerned, my lord. After that, a High Power Committee was constituted, my lord, in next page 55, my lord. Then constituted and they appeared before this, I mean to say, my lord, High Power Committee, my lord, but some the eligible candidate were left out, my lord. Then again, they have come before this honorable court and to place the matter before the High Power Committee, my lord. And accordingly, petitioner also come and place the matter in High Power Committee, my lord. That case is 56, page 56. His name is 34, my lord. Then, my lord, this committee, in this case, my lord, again, this honorable court pass an order to place the High Power Committee. Their names place the High Power Committee because at that time pick and choose manner was conducted, my lord. So accordingly, they have placed their name, my lord. But they have rejected my the petitioner's name, my lord, because your lordship kindly peruse that page 60, my lord. Why I have been rejected? Because I am second LDA in Madrasa High School, my lord. That all the teachers and teaching and non-teaching staffs all were second teachers and second LDA, second gate 4, my lord. But the High Power Committee has rejected these petitioners, my lord, that your lordship kindly look into the second para, my lord. The matter of the Abdas Samad Sheikh of Podumpara Ancholik Madrasa High School was placed before the committee, my lord. The committee finds that the petitioner prayed for regularization of his service as second LDA of the school, but there is no provision for the post second LDA in Madrasa High School. Therefore, name of the petitioner is not recommended as drop LDA of the school. My lord, he was rejected on this ground. Then I have filed one additional affidavit, my lord. I have shown that all the cases, all the person who were appointed, my lord, as a LDA, they all are second drop, my lord. Second drop LDA, my lord. That is page page 2 good. Page 2 69, my lord, 69. Para 2, my lord.
Page
70. My affidavit, additional affidavit. I have been shown that all the person who were dropped, my lord, as the example I have shown, my lord. That para 2, the deponent petitioner wishes to state that the Joint Secretary to the Government of Assam Department dated 13/3/16 initiated the petitioner that as per judgment order dated 10, the matter was placed before the HAPA committee in its meeting held on 16/2/16. The HAPA committee has disposed of the matter with a view that the matter Abdas Samad Sheikh of Podupara Ancholik Madrasa High School was placed before the committee. Committee finds that the petitioner prayed for regularization of the services of second LDA of the school, but there is no such post of LDA in a high madrasa. Therefore, the name of the petitioner is not recommended as LDA of the school. Such rejection by the respondent authority is not maintainable because one Sri Amir Uddin, who was initially appointed as a LDA, second LDA in Dihing Palm High School, regularized as a lower division assistant in Uttar Borpeta High School in the year 2012. Lordship, kindly peruse the peruse the annexure, my lord. His name is shown as para 4, serial number 4, and lordship, and his appointment letter I have annexed, my lord. That is page 72. Amiruddin appointment, my lord. I have annexed. It is shown that here you are appointed as a LDA second in Dihing Palm High School by MC resolution second dated 36/94, my lord. So all this the list.
Where's your the name?
His name is shown in the order, my lord. Serial number 4, Amiruddin, Uttar Borpeta High Secondary School, my lord. In pursuant of the government letter dated 12, my lord, 116 drop non-teaching staff, 17 numbers of LDA, 99 numbers of Gate 4 are hereby appointed in the school shown against their name and prospective effect. This has been issued with the approval of Finance Department 12. The appointment concern has to furnish an undertaking before joining school as prescribed by the Finance Department, New Pension Scheme 2005. That is my case, my lord. That the petitioner is second, Abdas Samad Sheikh is the second LDA. And all this as per after the passing this order, honorable court, my lord, all this the name of the shown in the annexure B, my lord, page 74. All are second LDA, my lord.
All this list.
Yes, this list is published after passing this honorable court, my lord.
Yes.
He was left out, my lord.
This list was published on 24 September 2012.
Yes.
In that time, my lord, there was separate act, my lord. Now it is 2017 act was coming to effect,
No,
my
this
lord.
case is, my lord.
And under 2017 act, my lord, here rules is provided for appointment of grade 4. And moreover, my lord, now one committee also constituted, my lord, to appoint the grade 4 commission. Yes. So all things are, my lord, done now. And in this affidavit, it is reflected those who are appointed in 2012, my lord. But now it is 2024, my lord. So, my lord, kindly keep it the part heard. So on next date, I will get prize.
My lord, I was appointed under Act, Provincialization Act of 1977, because that 2003 order has been passed. I have been appointed on the in the year. I have been appointed under the Act, my lord, not recent. And I'll show your lordships. Recently, one of my client has been appointed under this Act 2017, who is a drop teacher. I'll show you.
Where is that order?
No, I'm not bringing, my lord. I'll show you. It will come next week, my lord. I have already filed for his regularization, arrear payment and all. Next week it will come. I'll show lordship that recently one appointment has been made.
Where's that order?
Order is not with me, my lord. Order is
You
not.
furnished that copy?
Yes, my lord. On that day, next date, he wants time since he wants time. Under the Act of 2017. But we are appointed under the Act of 1977, my lord. So I have we have come in accordance with the High Court's order, my lord, not the Not any order that it was not that he will appointed another 2017. Only 2017 to appoint Korisa as a teacher. And 12 is on the 12 published. That is why we did not get. That is why we approached this honorable court, and honorable court passed an order to again place the high power committee. Then high power committee stated that on 16. This is a case of 17. This is a case of 17, my lord. 2732 2017. I came by 2017, my lord. On 16, they were rejected because I am the second drop LDA, my lord. But all the LDA who were regularized, they all are second drop, man. That is my case. And this honorable court also passed, my lord, some orders, my lord. I will place you, your lawsuits. They were, of course, gate 4. Abu Bakr Siddiq, my lord. This is gate 4. Hey, it will be it took 19 to হেৰি কি বুলি কয় তাৰ নাম কি আছিলে এপইণ্টমেণ্টটো যে পালো সোমবাৰে যে কেছ কি বৰগোহাঁই কি দীপক বৰগোহাঁই নহয় ইজন হা লক্ষীৰাম বৰগোহাঁই তোমালোকে লক্ষীৰাম বৰগোহাঁই বুলি এজনক এপইণ্টমেণ্ট দিছা 2020 মই প্লেচ কৰি দিম বাৰু This is gate 4, my lord. This is gate 4, second gate 4. This one is LDA. All are similarly situated person, my lord.
This order was passed in 2019.
19, yes, my lord. This is a case of 17, my lord. It was not listed, and they did not file affidavit, my lord. Then they have they deposited 15,000 was cost imposed them, my lord. There is an order, lordship. Kindly peruse the order. Because of that, they have paid 15,000, my lord, because delay of the filing the.
Another matter. Delay on filing affidavit, so 15,000 cost was imposed, my lord.
Imposed.
But already cost has already been.
It's not my
paid,
fault,
my
my
lord.
lord. It is not our fault
But
because they have
we have
obtained the order
filed our
and,
affidavit,
from
my lord,
the-
here, my lord, and
every year, my lord, they have taking time. That order is 3/3/2023, lordship. Kindly pay.
my lord, on next week, my lord.
Keep it part-heard, my lord. 3/3/2023.
I'm not giving it part-heard because you have to produce some orders also. You are saying recently someone was appointed, isn't it?
Yes, yes.
So the her name is KDV and council.
Recently. Huh? কেতিয়া দিছিলে?
On request
Into
made by
one.
Yush Hamal and the standing council,
Secondary education department.
secondary education. When do you want?
Next
week,
Tuesday, next Tuesday.
Is it okay?
next
Tuesday, হ'ব দিয়া, নহ'লে-
Thursday.
No, no, my lord. Otherwise, they will say that they have come now. They have. How can you get appointment? Because of them, my lord, this person is suffer. My petitioner is suffering because of that.
My lord.
Every day they will take come.
Senior
At that
colleague
time,
also
they
filed the
will
additional
not,
affidavit
department
on
dial, of
8/5/2024, my lord.
He.
Last 8/5/2024, they have filed the affidavit, additional.
No, earlier I was filed, my lord, but it was not. It was misplaced. That's why I won't be able to argue that on that day, my lord. That is why.
On 16.
Highly obliged. 16 দিছে হ'ব একো নাই
Finish.
16 Thursday, my lord. To me too.